hear this matter after 10th of July, my lords. Kindly see the order.
Please show me the order.
Paragraph 4 and 5, my lords.
বসেনি এদের সাথে কথা বলছে, এরা কথা বলছে।
Affidavit of opposition was directed to be filed within 7
They have not filed, my lords. Kindly take this up for hearing, my lords. In urgency is that my goods
Who
are
is appearing for the state in this matter?
state of West Bengal, my
Have
lords.
you put the state on notice?
Yes, my lords. I've served them through email, my lords.
Not
I have an
email, sir. Everyone is not as savvy as you are. So please serve a physical copy and come back.
Fine.
Okay?
Tomorrow.
Yes.
My lords,
Please serve a physical copy in the
my
meeting.
lords.
My lord, if I may.
Mention it. আলাদা করে motion গুলো আলাদা ভাবে hearing হবে।
এটা অন্য
Matter very.
অন্য কোর্টের কল নয়।
Court was pleased to grant stay
বাংলাতে কোর্টে কল হয়।
to the proceedings in the court below.
Yes,
My lord, I am praying for extension of the stay order.
extension of stay order.
My lord, may I be permitted to mention this matter? My lord, this is in a
Yes.
motion stage. My lord, Mr. Sakusin is going.
Eventually হচ্ছে, eventually হচ্ছে, এই মিথ্যে কথা বলছি। কি করব?
It was to come up on the list.
Eventually হচ্ছে।
Let
ওই
me
কি
see.
করবো?
Maybe, may. My lord, this matter, my lord,
কি করবে? বলছি, eventually
last
হচ্ছে।
chance was given for filing of affidavit in opposition to the respondent authority. But till date, my lord, the affidavit has not been filed by them or served to us.
Have you put the respondents on notice?
My lord, since the respondent office was closed during this period, my
So
lord.
please put them on notice and come
My lord,
back.
I have the, my lord, the notices are ready, my lord, but since the
To
office.
serve them, please
Well, I will
and
serve
come
in the
back.
course of the my lord.
Serve and come back tomorrow or day
My
after.
lord, he is here only, my lord. He is the respondent authority,
A
my lord.
formal service is necessary, sir.
My lord, I
in
will
course
serve
of-
it, my lord, in the,
Serve in course of this day and come back tomorrow.
my
Right?
lord, if my lord could allow.
One day heaven will not fall,
My
sir.
lord,
My lord, the inclusion on the list, this is the matter of
Yes.
inclusion of list. My lord,
I think I've taken 30 matters already, inclusion of in list.
list. My lord, actually,
Your lordship, he mentioned in
About 50
item
matters.
number
So
5.
my lord, can you day after tomorrow or
Let me see, give the numbers, I'll,
this is new motion, my lord. New motion.
Your lordship, beg to mention one, he mentioning matter item number 5, your lordship.
Another melody, may I permit to mention melody, 14 matter, মানে analogous matter melody, matter relating to interest on gratuity. 14 matter.
please mention after a couple of days. Let me deal with these matters after 2 days.
আমাদের ডাক হয়নি।
আমার একটা মেনশনিং ছিল বুঝলি,
Yes,
আমার একটা মেনশনিং আছে লাস্ট 21 জুলাই 2000 চিফ জাস্টিস অফ ইন্ডিয়ার অর্ডার আছে
আপনি in person,
ইন পারসন
appear করছেন? অর্ডারটা কি আছে দেখি?
9 নম্বর পেজে চিফ জাস্টিস অফ ইন্ডিয়ার অর্ডার আছে।
Oh.
শোনা যাচ্ছে না কোনো। শোনা যাচ্ছে না।
আপনি রেসপন্ডেন্ট কে নোটিশ দিয়েছেন?
হ্যাঁ হ্যাঁ
কোথায় আপনার সার্ভিসটা?
Your lordship. এগিয়ে যাচ্ছে। কেটে কেটে যাচ্ছিল।
চিফ জাস্টিসের অর্ডার কোথায়?
9 নম্বর পেজ
Okay. We have video video. Yeah, this is what I'm making.
এটা লিগাল সার্ভিসেস অথরিটিজ অ্যাক্ট অনুযায়ী স্টেপ
আবার
নিতে
কি
বলা হয়েছে।
হ্যাঁ, কিন্তু ওনারা আমাকে দিচ্ছে না অ্যাডভোকেট। আমার সার্কিট বেঞ্চে মামলায় হাইকোর্টের অ্যাডভোকেট দিচ্ছে, হাইকোর্টের মামলায় সার্কিট বেঞ্চে অ্যাডভোকেট দিচ্ছে, নানান রকম আমাকে হ্যারাস করছে।
এখানে কি আছে লিগাল সার্ভিসেস অথরিটি? Is there any member secretary or someone of the legal services authority at Jalpaiguri? Is anyone aware? Mr. Ghosh, are you aware? There is a legal services authority here.
Yes, it has been constituted that I am aware of.
So is there any member secretary or someone whom I can talk to?
Member secretary, my lord, we are not aware of. There is a panel.
There is a
মেম্বার
panel of-
সেক্রেটারি অ্যাকচুয়াল হাইকোর্টেরই হুজুর।
But who deals with it?
Well, I have to find out.
Because his grievance is, well, I'll speak to the registrar in that case.
Well, I'll also try to find out. my lord,
Yes,
if I can.
yes. Because his only grievance is the matter is not being, advocate is not being allotted for him. I'll find. আমি দেখে নিচ্ছি।
চলে গেল।
এটা আমাকে চেম্বারে দিন তো, আমি দেখে রেজিস্ট্রারের সাথে কথা বলছি, চেম্বারে পাঠাবো।
Also, may I point to mention also,
Yes,
in case new motion, last occasion, Honorable Justice Shobhito Bhattacharya they released this matter today, but not in listed. This is the order.
will be
My lord, may I be permitted to mention a hearing matter?
hearing. Yes, call the day's list, please.
Your lordship,
E-mentioning, my lord.
your lordship,
Oh, e-mentioning also. Yes, yes, right.
your lordship, e-mentioning item number 5, your lordship.
No, my number is 4. From 1, it is called your lordship.
Yes, Mr. Das?
Your lordship is e-mentioning item number 5, your lordship. My junior
Yes.
is there. It's an hearing matter, your lordship. I've served the other side notice and I'm mentioning it, your
Affidavits are
lordship, for
exchanged?
inclusion.
Affidavits are exchanged?
No, they have not given the affidavit, your lordship.
Who is
They,
appearing?
this is,
Have you
Your
put the
Lordship,
other side on notice?
yes, I put the other side on notice.
Who is appearing for the
I put
respondent?
the, your lordship, I'm the respondent over here. For the petitioner is Rahit Agarwal, I have served a notice. And for the West Bengal State Warehouse, it's Kamlesh Bhattacharya, I have served a notice, your lordship.
You've not received an affidavit in reply.
Yes, I have not received. This is a tender matter, your lordship. The entire thing is being
Let
stalled
it-
because
let
of
it
this
appear
matter.
As a hearing matter, let me see. Let it appear as a hearing
Yes,
matter. Please put
yes,
that
sir. Can it
on
be-
notice once again.
yes,
My
I
lord.
put. Can it be on your lordship Thursday, coming
can
Thursday, your
collect
lordship?
Let me see what the list forms.
Deeply obliged, your lordship.
My
Deeply
lord,
obliged.
my lord, might have your lordship emergency, mention item number 4. My lord.
Yes.
E-mentioning, my lord. E-mentioning item number 4, my lord.
Yes,
It is hearing matter, my lord. Hearing matter, my lord.
affidavits are
Item number
complete.
4. No, my
Affidavits
lord,
are complete.
in spite of direction, repeated direction, they have not filed their opposition. I am for the petitioner, tender matter. Your lordship kindly see, last order, first, my lord, Justice Arindam Mukherjee, Honorable Justice Arindam Mukherjee, directed, when the matter is taken up on behalf of the respondent, extension for time, opposition be filed for preemptively by 19, heading which the matter will be heard without affidavits. That was the direction. In spite of that, and
Mr.
matter will
Secretary,
appear.
have you put the other side on notice?
I've already served notice. The
Let
time
it
and again
appear-
served. These are
Let it
five
appear in the
time-
list. Let it
My lord,
appear
under
in
the
the
heading
list.
hearing,
Please serve
under the
again.
heading hearing, my lord.
Please serve again. Hearing
Deeply
matter.
obliged, deeply obliged, deeply obliged.
4. Hearing matter. Hearing. Push. Any other e-mentioning? Any other e-mentioning? No. Yes, days list.
Lordship, may I be permitted to mention?
Tomorrow.
Lordship,
Days list.
My lord, I'm appearing for the petitioner, lordship.
Please come back tomorrow, madam.
My lordship, I come from Alipurduar.
Mentioning? Really? Is it a hearing matter or a motion matter?
My lordship, one is hearing matter, one is content of court of this court.
Already, wait for that. File wait for the in person. File wait for the দেখে লিস্টে দেখতে হবে ফাইলে কি আছে রেকর্ডিং আমি ইন পার্সন করছি না ততটা বোঝা সম্ভব নয় একটু দেখে দুটো ম্যাটার আছে হ্যাঁ ফাইল দেখে yes item number 1
May it please your lordship.
yes you're for the petitioner
But my lord, I'm for the.
I'm appearing on behalf of CGST, that is respondent number 4 only.
what about the other respondents
State,
Both are represented, lordship.
oh Mr. Ghosh is appearing yes
My lord, before lordship gets into the thick of the brief, my lord, let me put the case in a nutshell. My lord, what has happened
take the
here-
microphone please
my lord. What has happened here is this, there was my truck standing in the parking lot and getting loaded. At that point of time, the respondents have come and I won't use the word detained or intercepted because since it was not in movement, the movement had not commenced. So it was apprehended, I should say, at that point of time. And my lord, the proceedings of detention and penalty had been initiated. Thereafter, I had also appealed against the adjudication order. The very basis of the matter for the respondents was that number one, the truck was not having any sort of documents, the tax invoice or the e-way bill, which are required for the movement. It was not there because the movement had not yet started. It had not yet been loaded. And secondly, which they have failed to point it out, but it is apparent from the records, there were a shortage of 70 kgs of goods. It is a consignment of more than 30,000 kgs. Only 70 kgs was short because that was not yet loaded at that point of time. And my lord, what happened, this truck was situated in such a parking position that it is the local authorities order that nothing should ply before 9 o'clock or 8:30. That changes from time to time. Now, being that the case, my lord, the case of detention and penalty has been built up against me as if it was in transit. But my humble submission is the truck was never in transit and that the records will show, my lord. Lordship will kindly come to the show cause notice, which is at page 42. This is the show cause notice, my lord. Form GST MOV 07, page 42 happens to be annexure P8.
yes
My lord. My lord, if I may place it from the third paragraph, that will be relevant. At around 3:47 PM on 6/3/2023, my lord, the date is very important. And the time, 3:47 PM on 6/3/2023, one goods vehicle bearing registration number such and such was intercepted at Bhaktinagar. Now, my lord, the word Bhaktinagar has been put in capital, but Bhaktinagar is a big place. Where at Bhaktinagar, it is from the parking lot that has never been mentioned by the officials of the BI, North Bengal. BI is Bureau of Investigation, North Bengal headquarters, Shiliguri. During the routine wayside check-in, the driver of the said vehicle was asked to produce the documents related to the goods being transported in this vehicle. The driver did not produce any document. He also stated he is transporting from Shiliguri to Punjab. Around 5 PM, Mr. Salim Mohammed, he is the proprietor, appeared along with the driver, Mr. Mohit Kumar, before me and produced one tax invoice bearing number such and such, dated this, and one e-way bill bearing number this, dated this, the same date. In the way bill bearing number such and such, dated this, and tax invoice this, the goods noted is old MS iron scrap of quantity 38,580 kg and value of consignment is rupees such and such. He also stated that he had sent the vehicle for payment on 5/3/23 evening, and after payment it was parked in the parking space near the weighbridge, as the vehicle was big one and could not be accommodated in their godown premises. It was Sunday. The office was not open. As the labor was available, he completed the loading. As the place is in the no entry zone of Siliguri, so he decided to generate the tax invoice and waybill letter before the opening of no entry. In the meantime, the vehicle was lifted from the parking place. My lord, this is very important. Why I say so? The vehicle was lifted from the parking place. It has been admitted here. And I will show your lordship.
Submission, not admission.
My lord, I will show your lordship at page 36, if your lordship, 34. If your lordship kindly comes, this is
Yes,
page 34, annexure P1.
yes.
This is the Bakra compound parking, which is again at Bhaktinagar area. Lordship sees the in time is 5:55 PM on 5th of March. And the out time is 4:30 PM, 6/3/23. That means after their detention at 3:47, I had went out. Of course, after they have detained, they will take the vehicle into custody. So it went out at 4:30 PM from the parking lot. It was parked since 5/3. That is for one. Then lordship might just remember, my lord, 7th of March was Holi. And for genuine concern, I had to load it before Holi. Because on and from Holi, lordship knows, it's a common knowledge, I cannot get laborers for at least 3-4 days minimum. So that was the only sole reason why this vehicle was being loaded on a Sunday, and that too in a parking lot. Before such completion, my lord, now my lord will kindly see, this was lifted from the parking lot, and on the next page, that is 43, page 43. Now comes the crux of the detention. Third paragraph, lordship sees, from e-way bill officer's app, it is found that the e-way bill bearing number this, dated 6/3/23, was generated at 4:14 PM by GSTIN number this, legal name this, trade name this, after 27 minutes of interception. So this is the clinching point why my vehicle was detained. That my vehicle had the e-invoice, e-way bill, only after 27 minutes of detention. My lord, I humbly submit that it is most emphatically true, because the moment I came to know that this has happened, I had generated the way bill and produced it before the authorities concerned. And at the time of detention, so within 27 minutes, I had the way bill. And obviously the tax invoice was already there. Now lordship comes to the next paragraph, most peculiar. In view of the facts as stated above, it is clearly appeared that the purported chain of transaction amongst the said RTPs are effected to conceal, suppress the actual consignor and consignee, which results in loss of revenue at the source and destination, as well as the stage of subsequent transactions due to cascading effect. Now, my lord, I pause here for a moment. My lord, from the narrated facts, I fail to coherently understand where from do they get this idea that I'm trying to suppress the consignor, suppress the consignee, and where is the cascading effect out here? I ask these questions to myself, my lord, because on the tax invoice, the consignor's name, consignee's name is apparent. The consignee himself appearing before the respondent concerned. E-way bill has been generated. Tax has been reflected and has to be paid. It is completely automatic. So at this juncture, this is, my lord, in my humble submission, it is the paragraph which does the round of the right departmental corridors, just to establish without any findings, my lord. This is not a findings. This is something of an opinion which has been thrust upon my shoulders. Now, my lord will kindly come to page 49, which happens to be the order under section 129(3), the fundamental impugned order. This is the order of penalty. How they're imposing penalty, my lord kindly sees. Page 49, I'm placing it from the very first paragraph. The conveyance bearing number such and such was intercepted by the state officers of Bureau of Investigation on 6/3/2023 at 3:47 at Bhaktinagar. My lord, here I join issues. Number one, it was not intercepted. A vehicle which was parked can never be intercepted. It was apprehended. And from where at Bhaktinagar? It doesn't say. It was the parking lot of Bhaktinagar, Bakra parking ground. The statement of the driver concerned was recorded on 6/3/23 itself. And then my lord will straight away come to grounds of detention. The driver did not produce any document during interception at 3:47 p.m. on 6/3/2023. From e-waybill officer's app, it is found that the e-waybill bearing number this, dated this, was generated on this 4:14 p.m. by GSTIN number this, legal name this, trade name this, after 27 minutes of interception. So the same thing is the same thing that is being repeated. And thereafter, the same crux, the same conclusion. In view of the facts stated above, it is clearly appeared that the purported chain of the transactions amongst the said RTPs affected to conceal, suppress the actual consignor and consignee, which results in loss of revenue at the source and destination as well as the stage of subsequent transactions due to cascading effect. Lord, once again, tarrying here for a moment, Lordship will see the whole thing has been copy pasted. Even the grammatical error remains. Even the grammatical error remains, my lord. Thereafter, from the above discussed facts, it is clear that the consignments details as stated herein above were being transported is in contravention of section 68, 129(1), read with rules 138, 138A, etc. Now, my lord, pausing here for a moment once again. The transportation, with all humility I submit, had not yet begun. They are making use of section 129(1), section 68 out. Lordship, I'm giving section 68 and I'm also marking section 129(1) for your lordship's reference. I'll place this. Thank you. My lord, section 68, lordship kindly takes first.
In movement.
My lord, section 68, so my lord, section 68 is inspection of goods in movement. I need not go into the details of the provision at all. Inspection of goods in movement. My goods were not in movement. The government may require the person in charge of a conveyance carrying any consignment of goods of value exceeding such amount as may be specified to carry with him such documents and such devices as may be prescribed. Then again, subsection 3, where any conveyance referred to in subsection 1 is intercepted. Neither was the goods in motion, nor was it intercepted. So section 68 has no bearing, no application in this matter. Thereafter, lordship kindly comes to 129.
Yes.
My lord. This is the mother provision of under the GST Act, as lordship knows. Detention, seizure and release of goods and conveyances in transit. Notwithstanding anything contained in this act. My lord, once again, I harp upon the word in transit. It has to be in transit. Notwithstanding anything contained in this act, where any person transports, my transportation had not begun, any goods or stores any goods while they are in transit. It was not in transit, so I was not storing it on the lorry. In contravention of the provisions of the act or rules made thereunder, all such goods and conveyance used as means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released ABC on payment of penalty. I'm not getting into it. So, my lord, 129(1) itself is for goods in transit. 129(3), under which this order of penalty has been issued, that is again, I'm showing that 129(3), my lord. The proper officer detaining or seizing goods. My lord has got
Yes,
it?
yes.
Lordship, grateful. The proper officer detaining or seizing goods or conveyance shall issue a notice within 7 days of such detention or seizure, specifying the penalty payable, and thereafter pass an order within a period of 7 days from the date of service of such notice for payment of penalty under clause A or B or of section 1, subsection 1. So here again, it has to be a goods which has been seized or detained where it is in the conveyancing process. A question might arise that this is the same provision which works for godown seizure, warehouse seizures as well. My lord, I most humbly submit it is not the case. Section 67 happens to be the relevant section for such. Lordship will kindly come to section 67.
Yes.
My lord. কোথায় গেল? Power of inspection, search and seizure. This is the general provision. My lord, under the GST Act, if I may say so, there are two types of inspection, seizures, detention possible. One is for the goods in transit and the other in general. So this 67 is the general provision, which has never ever been referred to in the instant case. Where the proper officer not below the rank of Joint Commissioner has reasons to believe that these suppressions have been made, A and B, he may authorize in writing any other officer of central tax to inspect any place of business of the taxable person or the persons engaged in business of transporting goods or the owner or the operator of warehouse or godown or any other place. This is the power of such. Then, where the proper officer not below such and such rank, either pursuant to an inspection carried under subsection 1 or otherwise, has reasons to believe that any goods liable to confiscation or any documents or books of things which in his opinion shall be useful for or relevant to any proceeding under this act are secreted in any place, he may authorize in writing other officers of central tax to search, seize, or he may himself search and seize such goods. This is the power of seizure. So the power of seizure and the power of inspection or verification is completely different for any other purposes. If they wanted, they could have searched my godown, my warehouse. They could have seen my books of accounts, but they did not do it. They chose to go for a wayside checking. For that matter of fact, my lord, any consignment can be seized. If today I go with my officials and team and all on a sudden amidst of my loading, just get hold of it and seize it, obviously the goods will be incomplete. Obviously the documentations will be incomplete. That is what has happened, my lord. And this was repeatedly stated, even in appeal. Lordship kindly sees my appeal petition. Page 51, Lordship kindly comes to. Here, before that, Lordship will kindly, I'll just finish with this detention or order of penalty. Page 51, my lord.
Yes.
Grateful. Number 3, the owner of the goods or person in charge of the conveyance has filed objection as under. He also writing. The RTP had sent the vehicle for weighment on 5/3/23 evening. After weighment, it was parked in the parking space near the weighbridge. As the vehicle was big one and could not accommodate it in their godown premises, it was Sunday, the office was not open. The laborers as available, he completed the loading. As the place is in no entry zone of Siliguri, so he decided to generate the tax invoice and waybill letter. He is paying penalty to release the vehicle. The objections filed by him were perused and found acceptable or not acceptable for the following reasons. From e-waybill officer app, it is found that e-waybill bearing number this, dated this, generated on this, was generated after 27 minutes. Then number 2, it is not possible to load the vehicle without finalization of purchaser. My lord, once again I pause here. There is no question of non-finalization of purchaser. I am having the tax invoice. Until and unless I have sold the goods to somebody, I cannot load it thereafter. There was an intention to evade tax and transport the goods without documents. I do not know where from this comes. I ask this question to myself. There was enough time to generate tax invoice and e-waybill from morning to 3:47 p.m. 6/3/2023. My lord, now this is something of a subjective satisfaction. From morning till 3:47 p.m. I had the time, but did I have the legal obligation? No. I only will have the legal obligation once my vehicle starts plying. Not even when it is completely loaded. Once it starts plying, then only I have the legal obligation. So this is basically, my lord, this is purely on surmise, conjecture and unfounded. In view of the facts above, it is clearly appeared, the same paragraph again appears. It is clearly appeared that the purported transaction amongst the said RTPs are effected to conceal, suppress the actual consignor and consignee, which results in loss of the revenue at the source and destination as well as the stage of subsequent transactions due to cascading effect. The same things doing the round, my lord. Now lordship kindly comes to page 63. This is my memo of appeal. This is a part of my memo of appeal where I have narrated the facts.
Yes, 63.
Lordship, grateful. My lord, I'm placing it from the second paragraph, third line, from the third line of the second paragraph. The vehicle, my lord has got it. The vehicle,
Yes.
the vehicle had to be loaded from the godown of the appellant and thereafter have to send to Weybridge for payment and ultimately would have started its movement Sunday night, according to the time instructed by the local authorities to ply heavy loaded vehicle through the city. Since 4th day of March 2023 being Saturday and the next day being Sunday, the office would remain closed. So also it would be very difficult to arrange laborers for loading. Further, it is worthwhile to mention herein that on 7th March 2023 was celebrated as Holi all over India, and your honor will certainly agree that in this part of the country it is very much difficult to arrange labor prior to this kind of festival. Keeping in view of this factor, the appellant hurriedly loaded the scrap items in vehicle bearing number this on Saturday. The loading from godown was not complete, as few other small supplier of scraps was supposed to bring the materials in rickshaw van. But to let ours, we instructed them to reach the parking lot and complete the loading thereat. But due to precautionary measures, we instructed to wait the incompletely loaded vehicle and park the same in the parking lot at 2.5 mile Sebok Road near checkpost Siliguri. The vehicle was stranded at the parking lot on 5th March 2023. That is Sunday, as the loading was not completed, and also being a Sunday, a holiday under Shop and Establishment Act, the consignor was not able to use its official infrastructure for generation of invoice and waybill. In this current position, there are 3 points to be mentioned. Number 1, the loading was incomplete. Number 2, the movement of vehicle to its destination has not yet commenced. And number 3, since loading and final payment has not been done, therefore tax invoice and e-way bill cannot be made thereafter. On the next page, officers of the Bureau of Investigation such and such came to the parking lot and intercept the vehicle at 3:47 p.m. on 6/3/2023. At the time of interception, the driver could not produce the waybill and invoice at the point of time, and the same when not generated as the final payment of consignment was not made. Of course, I cannot make the payment, and without weighing, I cannot make the waybill. The officer of the Bureau of Investigation, North Bengal headquarters, detained the said vehicle and took it to the commercial tax office at Matigada. On getting such information from the said driver, supplier issued a tax invoice and generated the e-way bill showing the quantity which was weighed on such and such, and produced it before the appropriate authority at commercial tax office Matigada around 5 p.m. The officers did not consider the tax invoice and e-way bill produced by the supplier on this itself and issued GST MOV part 1, and thereafter the proceedings started. This was my facts. And then again in the next page, my lord, only one grounds I'll show, that is paragraph 2, lordship sees that the goods along with vehicle in question has not completed the loading process and also has not commenced its movement. Hence, invocation of section 68 along with 69 is not sustainable in law, and hence it should be set aside.
That's what you have submitted.
Yes, I had also taken this point in appeal. Facts and the grounds, they say so. Now, my lord kindly sees the appellate order. It is peculiarly quiet on these issues, and they had never, and the written submission is also there, page 67. I am not going through the written submission once again, my lord, because that will be again repetition, 67 and 68. Here I have only added one small little point that under section 122 of the GST, it, my lord, page 68, lordship kindly sees the last 4 lines.
Yes.
The last paragraph. In the instant case where the loading and payment process is not completed, how the appellant would generate the tax invoice and e-way bill? It is pertinent to mention here in that under section 122 of the GST prescribes that issues any invoice or bill without supply of good or services of both is an offense. Hence, in this instant case, supply has not affected, then how appellant would issue tax invoice and e-way bill? Since the movement of the goods has not started, and hence imposition of penalty under section 129 is not justified. So that was the thing. They say, why haven't you done it at the time of loading? I couldn't have, until and unless it starts. Thereafter, my lord, the final impugned order, page 69.
Yes.
From the second paragraph, Lordship sees the facts of the case has been narrated. One conveyance bearing this was intercepted by a team of officials. Although it was not intercepted, it was apprehended. Thereafter, the goods in movement were inspected. My lord, it was not the goods in movement, the goods stranded in the parking lot. Then Lordship kindly goes to the next page. They had made a few references to section 129 and section 138 capital A. My lord, at the page 70, Lordship will kindly take the second paragraph. The consignment of goods, old iron scrap loaded on the impugned vehicle were physically verified on 9/3/2023 in presence of driver or person in charge of the vehicle, and form GST MOV 04 was issued. As part the verification report issued in GST MOV 04, there was a difference in quantity of goods in between documents tendered and the actual quantity found as per physical verification. My lord says this is for the first time this is appearing. Despite my pointing this out time and again, it had not been recorded in the adjudication order. Why? Because it will unmistakably show that my loading was not completed. Only 70 kgs. Here, my lord, the amount, the difference has not been stated. At the end of this paragraph, Lordship sees the paragraph starts, the line starts with, again, there was also difference in quantity of impugned goods detected as per physical verification report dated 9/3/23. Quantity as per tax invoice was 30,580 kg, whereas quantity as per physical verification was found 30,510 kg. My lord, the difference is only 70 kgs, and that is why it has not been stated, because this goes to show, prove, establish my bona fides, and it shows how high-handedly the whole thing has been done. Otherwise, this difference of weight, the department would have come out with all their armors blazing and swords shining. Thereafter, my lord says, it becomes pertinent to mention here that as per the provisions of the Act, the conveyance found to be transporting goods without an e-way bill and tax invoice shall be treated as contravention of section 68 of the GST Act and read with corresponding sections of CGST. Then they go on to cite 138(1), which, my lord, I have already showed your lordship. 138(1) is also every registered person who causes movement. Then again, it is ousted. If it is causes movement, then it is not my case. Then, my lord, kindly turns on to the next page. 138A, they have sought to apply on the next page. Again, documents and devices to be carried by a person in charge of a conveyance. My conveyance has not yet started. And thereafter, again, the person in charge of a conveyance. Then, my lordship, is 129. I have already showed your lordship. Last but third paragraph, my lord. In view of the above discussions, there is sufficient reasons to believe that the impugned goods so being transported in the impugned conveyance were being transported in contravention of the provisions of 138(1), 138A(1) of the GST rules, read with corresponding rules of CGST. Now, my lord, all these facts and grounds that I had taken, saying that this is not applicable from the very beginning, from the very rudimentary stage, this has never been addressed, because even they know it is not acceptable. It is not applicable at all. And as an end result, what I had to do, I had to pay the full penalty and then get my goods released. And it was a long harassment. My lord, your petitioner from 6th of March has been suffering. Today, my lord, I could come before your lordship and place the case. So, my lord, in this backdrop, my lord, I'm praying for the quashing of the seizure, the detention and penalty, lordship.
When did you pay the penalty?
My lord, I had paid the penalty. It is at page number GST movie from page number 57. Lordship kindly comes, and except page 13, and thus I have secured the release, my lord. This was paid on 10th March 2023. It's 4,95,396. This was paid.
That's all your sufficient.
My lord, my lord.
Yes.
So now, if Millard kindly takes Millard rule 138 first. The WBGST Act and the rules, Millard, the rules WBGST rules, my lord, rule
My lord, it is
138.
same as the CGST. That book has it.
138.
138,
Yes.
rule 138. My lord, the marginal note, information to be furnished prior to commencement of movement of goods and generation of e-way bill. My lord, every registered person who causes movement of goods of consignment value exceeding 5,000 rupees in relation to a supply so and so, my lord, there are certain statutory duties cast upon. My lord, one of the mandatory statutory duties which has been cast upon by way of section 129, read with rule 138, is to, my lord, generate the e-way bill and pay the tax. Tax
Is it your
invoice and
case
e-way
that
bill.
movement was caused?
Yes.
It is not your case.
Yes, Millard, kindly, Millard, the records will speak for itself. Millard, the records has not been shown entirely to Millard. Millard would first come to page 37. That is, Millard, the order of physical verification and inspection of the conveyance. Page 37. Millard, the goods conveyance bearing number so and so, carrying iron scrap goods, was intercepted by the undersigned, the designation of the person, on 6th March 2023 at 3:47 PM at checkpost Bhaktinagar. Checkpost Bhaktinagar. And Millard, in some places it has only been stated Bhaktinagar. Bhaktinagar, Millard, is a large area. And Millard, the exact point of interception was the checkpost. Now, Millard, kindly sees how, Millard, the documents have been manipulated. Millard, come back to 34 once. The document on the basis of which they say that the vehicle was in a parking lot. Millard, page 34.
Yes.
Kindly sees, this is a purported receipt, probably. Serial number 049, date. The generation date of the receipt is 5th of March 2023. Now, Millard, on 5th of March 2023, how can someone certify the out time? The out time is 4:30 PM, 6th March 2020. That's what is written over here. So that apparently this is a, Millard, a procured document which has been subsequently procured. Now, Millard, turns to the e-way bill. Millard, on prima facie perusal of this document, Millard, I see on 5th March, the authority of the parking lot cannot certify the out time, which is 1 day later. Millard, secondly, Millard now comes to the e-way bill, Millard, which speaks a lot. Page 40. Millard would find that it has been generated post facto after Millard, the detention has happened.
That is admitted.
That is admitted. Now, Millard, kindly sees the address details. That is, Millard, the column number 2, from and to. From Waris Enterprise, West Bengal, dispatch from. Millard, see, there is an address provided here. So the origin of the goods is this address for all purposes of the statute. The origin of the goods has to be treated from this address. And Millard, admittedly, the place of interception is Bhaktinagar. Bhaktinagar checkpost. Therefore, Millard, from the records itself, there cannot be any prima facie doubt that the movement has actually started or commenced. And Millard, kindly see the contradiction in their own version. Millard, we would kindly come, Millard, to their written version, which is their stand, reiterated time and again. Millard would find that, Millard, their written submissions just prior to the appellate order, that is at page 67. Annexure P15.
At page
67. Millard, this version has been ran, Millard, several times. Millard, I'm just showing it from this document.
yes.
Millard would just come at the middle of the page, the second paragraph, later part. The loading from godown.
Yes.
The loading from godown was not complete, as few other small supplier of scrap was supposed to bring the materials in rickshaw van, but due to late hours, we instructed them. Millard, kindly mark the words. We instructed them to reach the parking lot and complete the loading thereat. Which means, Millard, the incompletely loaded vehicle, as even if I treat it to be incompletely loaded according to their version, was moved from the original place of origin, Milord, to a parking lot, and Milord, subsequently, Milord, they have probably, Milord, Milord, into a journey within the city, or they were attempting to, Milord, take the goods out of the city through the check post area, that is Bhaktinagar. Loaded vehicle, complete the loading there, but due to precautionary measures, we instructed to wait the incomplete loaded vehicle, park the same in the parking lot at so and so. So, Milord, from the e-way bill, there is a place of origin determined, it cannot be changed. There, it has been submitted by them. The place of interception, and Milord, their statement. And Milord, the place of interception, which has been specifically mentioned to be the Bhaktinagar check post. Milord, there cannot be any doubt that the vehicle has commenced its movement from its place of origin. And Milord, even without going into any mensary or intention, Milord, within the scope and meaning of the GST Act, commencement of movement, even if it is of 1 inch, Milord, it is an offense. And Milord, kindly envisage the practical situation. Milord, thousands of vehicles are moving. Milord, which vehicle is moving from, Milord, the place of origin? Probably it will go 2 kilometers and take shelter somewhere. Then again 5 kilometers, then out of the city. Now, Milord, the officers has to go by the rule. If there is a movement, there has to be a document. The statute has to be, Milord, complied with. If there is not, Milord, there is a statutory duty, penalty have been imposed. And Milord, kindly also consider this today. After the adjudicating authority has passed the order, in presence of them, there's no case run as regards, Milord, violation of natural justice. The appellate authority has applied his mind to facts. Now we are at the second stage, akin to a second appeal. Now whether Milord can go into the facts as this stage, and that also, if something palpably wrong has been demonstrated before your lordship, that has not been done. So therefore, Milord, in my respectful submission, Milord, there is no infirmity in imposing the penalty. It has been done in accordance with the
Yes, you are for the fourth respondent.
On behalf of respondent number 4,
Yes.
my submission is that the CGST authority has no role in this matter. So the name of CGST authority may kindly be deleted. This is my humble submission.
My lord, may I reply? First things first, Monpuri Basti and the place of their detention, as per them, 8 minutes by walking. Lordship kindly says.
How do you respond to the? place of
Everything I will,
origin?
one by one, everything I will do. 8 minutes, 1.8 kilometers. Now, as my learned friend has said, even 1 inch. This is the first thing that I show. The second thing is, Lordship kindly comes to page 37. As my learned friend has pointed it out.
Yes.
Check post, Bhaktinagar. May I ask my learned friend, which check post is this, sir? Page 37, check post, Bhaktinagar. Perhaps I should have shown this. My lord, there is no check post of the GST authorities in Bhaktinagar. I am placing this on record. It is the check post of Forest Department.
He has not said is the GST.
My lord, that is what I am saying. This check post of Forest Department, it is adjacent to this parking lot.
Page 34, your document
37.
also says near check post.
Yes, because it is just near, beside the parking lot, it is the check post of the Forest Department. And here 2 + 2 makes 4, my lord. My document says near check post. This check post is not GST check post. This is the Forest Department check post. And here at page 37, I am thankful to my learned friend. He has showed check post Bhaktinagar. It's the same place.
How do you respond to page 40, the place of origin?
My lord, I'm coming. But there is another point that my learned friend said, that he could not fathom how could at the entry time they could write the exit time. No bill is given at the entry time in a parking lot. It is a common knowledge. When they took my vehicle out, I had to pay this 100 rupees and they gave me this receipt. And in that it was entered as the entry time to be 5:55 PM and the exit time to be 4:30 PM.
Bill was issued on 5th.
It was not issued, my lord.
The date.
Date is 5/3/2023, 5:55 PM. The date is 5/3/2023. Yes, it will be issued. It will be issued on 40. The serial number 49 will be issued on 5th because I have entered on 5th. but the out time will be noted down when I go out. So this part in their receipt book, 5/3/2023 is filled up, in time is taken. That is how they count their money as well, my lord. When I take my vehicle out, they simply in their book only, they simply write it down 4:30 p.m. 6/3/2023 for so much hours you have to pay so much amount. That is how the receipt book is maintained, and that is how the receipts are given.
Explanation is not very clear, Emma.
My lord, I will once again, in a case of a parking lot, say in case of airport authorities, nowadays airport authorities are giving out slips. If we go into any mall, in any mall, whenever we go and park our vehicles, they do not give us any receipt, but they make a note of our entry time. And then when we come out, then also they have a note in the exit time. And
That's the same day in and out.
same day in
When
and
it's
out.
on the next date, the
yes,
bill
now
has to
had
be
it.
issued on the next date, not the
No,
earlier
it
date.
is not the bill,
Isn't
it is
it?
the receipt, or it is, well, this is how whenever a parking is done in any common parlance case, I can show, even produce the book, the receipt book. In any common parlance, 49 is reserved on 5/3/2023. Maybe there are hundreds of vehicles after that there are 100 more vehicles. And they will, when they will tear it off from the receipt book, they will simply write 4:30 p.m. the out time. And at page 40, as my learned friend was showing, this Monpuri Basti and that is what I showed your lordship, it's 8 minutes difference. Now, why did I have to go even an inch? True. Lord, before sending or dispatching a consignment, it is not a few kilograms. The consignment is of 30,580 kilograms. A weighbridge is needed. The nearest weighbridge is there at the checkpost area where the parkings are made. My movement has not started because I have not finalized my consignment. I have to first finalize my consignment. It's iron scrap. I have to measure it, that this is 30,580. It is not 40,000.
The loading is not.
Kindly, let me complete. Yes, the loading has to be completed in the weighbridge area only, because there are other people bringing in their own goods while loading into the vehicle. I don't have such a big warehouse. The GST laws do not ask me to have a big warehouse.
Have you referred to this place of origin in your appeal?
Place of origin. This
Yes.
is the first time they are taking this plea. I was not required to take
This is
this.
your document.
My lord,
This explanation was needed to be given before the authority.
my lord, my explanation was confined to 27 minutes delay. Till now, they were on 27 minutes delay. Now they are making out a third case. That your lordship will kindly consider whether to allow them to make a third case or not.
Can
Because
you
they are,
depend on a case being made out by the respondents, you have to place your cards before the authorities.
my lord, I did, because I have never thought of that they will come up with this plea that your vehicle has started moving. Because nowhere, I have repeatedly said that I was not in movement. Nowhere in their documents had they ever said that no, you are under movement. They have simply sidestepped the issue. What precluded them? I asked this question to myself. What precluded them to write one line and say, no, you were under movement. Your goods were in transit. From the very beginning of time, my lord, I have been canvassing my point that I was not under movement. I was stagnant. I was stationed. From the very first day I'm saying this. They have never said this. Now, before your lordship, they are coming out with a third case that I was under movement.
Prima facie, there has been a movement from your place of origin till the weighbridge.
No, my lord.
Fine.
The place of origin will be my Monpuri Basti only, because technically speaking, after weighment, this vehicle will fly down to my office at Monpuri Basti, collect the documents, and then he will start the movement.
Have you stated that in your writ petition? No.
Because
Or even before the appellate authority? No, that's
yes,
not
I have
like that.
stated it time and again that it went there for weighment. It went there for weighment. I have stated it that time and again. Lordship kindly sees.
Cannot go there. How can it go there for weighment before the vehicle is fully
No, my lord,
loaded?
what happens when the goods are very heavy and hefty in size, then if I'm taking 3-4 person, I'm purchasing scrap from somebody and then I'm loading it into the vehicle. I ask them to go and send the scrap to the directly in the weighment site. because otherwise it will be repetitive expenditure. They will come to my place, I will load it, and once again they will go before the because my lord, I should perhaps point out how the process of loading is done. The process of loading is done by emptying the vehicle first. They take the empty load and they then load it,
Yes, the gross vehicle weight has to be
and
taken
then
first.
that is deducted. Now, my lord, if I do not load my vehicles in the Wayman Bridge, there will be twice loading charges. I will be loading once in my godown and then again in the Wayman Bridge. That is not the way that the commercial. No, that's not the case.
Gross
This question
vehicle-
never cropped up.
Gross vehicle weight is in your registration. The smart
Absolutely,
card.
absolutely,
So
my
you
lord. That
don't
is
need
how.
to, empty the vehicle and weigh at the.
That will entail twice the loading charges, my lord. I have to load it twice. And loading a vehicle entails a good amount of charge. 31,000 kgs of load when
Will
it is.
you go before the appellate authority for a reconsideration? Because what you are saying was not placed before the appellate authority.
Only one thing, my lord, will kindly direct them, or rather observe, my lord, that if my vehicle was not in movement, section 68 and 129 one should not be applied.
I'll
If they can,
record your submission. I'll record your submission.
yes, that is what I'm saying.
Because what he says is a new case made out.
Absolutely.
This was not dealt with by the appellate authority at all. Maybe it was not placed before the appellate authority.
Because, my lord, the
And you
occasion
are
did not
also
arise.
most probably raising the issue here and here. itself.
Yes.
We have no difficulty with that.
So let it be reconsidered by the appellate authority, because otherwise prima facie, I do not find anything to interfere.
Because, my lord, my only humble submission is this,
So-
that here what has happened, for the first time they are coming up and saying that you are under movement.
No,
Till
that is
now-
the entire basis of the order.
No,
What
no.
he's saying.
That's
No.
the reason why I would like the appellate authority to reconsider, because
Ma'am,
otherwise.
yes, it is true. It is non-speaking on that count, because he has not.
Otherwise, whatever you've submitted before the appellate authority, an order has been passed, and I really do not find anything. wrong with the
Consideration of
order.
that. Madam.
So without going into merits, I'll record your submission, go back before the appellate authority, let them decide.
And let them say that whether it was under movement or not.
They have said that already.
My lord,
That is
they
the-
have
That is
not.
the basis of.
They have not,
imposition of
my lord.
penalty.
They have recorded that, your movement.
My lord, that is tacitly they have said intercepted during movement or when the goods are in transit, like that. But when I have categorically mentioned that you had detained it in the check post region, you have detained it in the parking lot, they have never refuted it. Neither the adjudicating authority nor the appellate authority.
Yes, do you agree to a
Yes, my lord.
reconsideration by the
Yes,
authority?
yes, I do.
Heard learned counsels for the parties.
But my lord, in my writ petition, I have already stated that it is for the purpose of payment. It was in the parking lot. That I have stated in my writ petition.
Yes, yes. But you've not clarified the place of origin, the
True, my
way,
lord, because this
the-
question never arose. True.
paragraph at the outset. The Commissioner of Central Goods and Service Tax, Siliguri Commissionerate, being the fourth respondent herein, has submitted. But it is submitted on behalf of the insurer. At the outset.
My lord,
submitted
one
on behalf-
small humble request, my lord. As my learned friend has already submitted that CGST has got nothing to do on this. It's my duty to point out that every demand made out by either SGST or CGST, half of it is claimed by CGST or SGST, vice versa. So, my lord, today I have to make them a party, because otherwise it will be your lordships giving out an order without hearing an interested party. That will be lordship knows
I'm
much
not
better
ac-
than.
I'm not in fact expunging his name. I'm just recording his submission
Mine,
that he says
mine.
he has no role to play any further.
Because only
Because the-
fear is.
Yes, yes. Interception was done by the SGST.
True, but the penalty and the tax goes to both of them. So they are an interested party, and
Interception
I
was
fear the
separate.
non-joinder of parties, my lord, nothing else.
Uh, On behalf of the Commissioner of Central Goods and Service Tax, Siliguri Commissionerate, being the fourth respondent here in comma, that since the vehicle was allegedly intercepted by the state tax officers of the Bureau of Investigation within bracket North Bengal, bracket closed headquarters, comma, the fourth respondent has no role to play herein. On merits, comma. It is submitted on behalf of the petitioner. That in course of sending his consignment comprising old MS capital iron scrap to Messrs M/S Uttam Steel and Agro. Consignment comprising of weighing weighing 30,580 kilograms to the vehicle was parked in the parking lot at Bakra compound.
Bhakra compound.
At Bakra compound, since it was not completely loaded and movement of the vehicle to its destination had not commenced. Stop. The vehicle was allegedly intercepted by the respondent authorities from the parking lot and a detention order passed under section 129 within bracket 1 of the Central Goods and Services Act, Services Tax Act. In form FORM GST gap MOV 06 dated March 9, 2023. Penalty FORM. Penalty to the tune of rupees. What was the penalty amount?
My lord, the penalty amount is 4,95,000.
At page
57, 4,95,396. 57, my lord.
4,95,396 was slapped upon the petitioner for violation of section 68 and 129 1.
29
68 and 129 within bracket 1 of the Act. A capital. The order of penalty was carried in appeal by the petitioner and the appellate authority, comma, by an order
dated
passed on
June
2nd
2nd.
June 2022, comma, dismissed the appeal primarily on the ground that the conveyance was found to be transporting goods without an e-waybill, e-waybill and tax invoice in contravention of section 68 of the Act of 2017 of the WBGST Act, WBGST Act of 2017 corresponding to section In the CGST also, it's section
Same,
68.
same.
68 of the CGST Act 2017, read with Rule 138 of the WBGST rules, comma 138 of the WBGST rules, comma 27. Paragraph. Learned counsel for the petitioner submits that since the vehicle had not commenced transportation and was parked at the parking lot for further loading, comma, the provisions under section 68 or 129 of the Act have no manner of application in the present case. Loading of the vehicle was yet to be completed, and the vehicle was partially loaded, as the relevant date was a holiday followed by 7th March, which was celebrated as, which was Holi, H capital Holi, which is celebrated throughout the state. Admittedly, the vehicle was allegedly intercepted the e-waybill demonstrates that the same was generated on 6th March 2023 at 4:14 p.m., 4:14 p.m., comma, that is, comma, after 27 minutes of the alleged interception of the vehicle. Stop. Learned counsel explains that the e-waybill was generated immediately after the vehicle was intercepted. Since there was no occasion for generating the same prior to completion of loading of the vehicle and its transportation.
Weighment.
And its weighment and transportation. And its prior to of the vehicle and its weighment and transportation. Paragraph. Per contra, comma. Learned counsel for the state respondents submits that Form GST space MOV -02 issued on 6th March 2023 indicates that the vehicle was intercepted at the check post at Bhaktinagar. And the e-waybill suggests that it had commenced movement from Manpari Basti, Manpari Basti. On the date is not reflected, isn't it?
My lord, the date is,
6th it was generated, but the movement date is not reflected.
my lord, it's,
The UAB is not.
it is the validity within which I have
Right,
to
right.
complete my.
The
First,
movement has
stop
to be-
comma, meaning thereby that the vehicle was in movement when it was intercepted. Paragraph. No, also, comma. The receipt issued by Bakra Compound Parking indicates that though the vehicle left the parking compound at 4:30 PM on 6th March 2023, comma, the receipt was issued on 5th March. These are the submissions, 5th March 2023. Stop there. So the said receipt was subsequently procured by the petitioner to substantiate his case. But these issues, some of these issues have been raised by the parties in the writ petition for the first time and were not dealt with by the appellate authority in considering the submissions made on behalf of all parties in appeal. Stop. In view of that paragraph, in view of the above comma, this court is inclined to hold that the matter be remanded to the appellate authority for revisiting the same upon consideration of the submission which may be made on behalf of both the parties before the authority.
My lord, let him come to a decision that whether it was in movement or not.
That's
Well,
the primary decision to be taken.
My lord will kindly indicate it, because then again they will sidestep and I have to come once again, my lord.
The appellate authority shall arrive at a decision as to whether the vehicle in question was in movement at the time of interception of the same.
Apprehension, my lord, apprehension. Apprehension includes interception as well, but interception does not include apprehension.
Alleged interception.
Alleged apprehension, lord.
Let-
Because
They
apprehension,
have used the term interception, so let it be interception.
Interception can.
Let it be alleged interception. কি বললাম? Arrive at a decision. D হবে না। D না, arrive, ED না, arrive at a decision, হ্যাঁ। হুম, হুম, হুম। Same. Comma, thereby attracting the provisions laid down under section 68 and 129 of the Act of 2017. Paragraph, accordingly, the writ petition is disposed of. Directing the, who should be the authority to consider?
my lord, the respondent number 2, Senior Joint Commissioner.
Directing the second respondent to reconsider
Joint Commissioner.
the
My lord, within a finite time, your
absolutely,
lordship.
absolutely, reconsider the appeal upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, within and pass and pass a reason and speaking order thereto within 1 month, within 4 weeks from the date of communication of this order, comma,
Grateful,
in
my lord.
accordance with law. Paragraph, the parties shall be at liberty to place relevant documents before the concerned authority at the time of appeal. Paragraph, it is made clear that this court has not gone into the merits of the case, and the authority shall be at liberty to deal with the appeal independently without being influenced by any observation which may have been made in this order.
Grateful,
Grateful, grateful.
You can take back your book.
grateful. My lord will require this book.
Huh?
As a-
Short judgment has been, what do you need? This was not the judgment. Yes, next.
But I'm appearing for the petitioner.
My lord, in item number 2, kindly allow me 2-day accommodation. Day after tomorrow,
My
kindly
lord,
fix it day
there is-
after
I'll
tomorrow.
just show, my lord, it's a
Because,
very short point, it's point of
Just I have-
limitation.
I have received the petition, copy of petition only just Saturday.
And let him
So,
come back. Let him come back.
My lord, I will
Just-
just only show one thing, it's
He
a
has
question of
Day after
limitation.
tomorrow, day
He
after
has to
tomorrow,
go through the
I'll argue,
documents.
day after tomorrow.
Allow him to
Tomorrow,
go
my
through
lord,
the
I will be
documents.
stranded here for the next 2 days.
Now the circuit bench will be
I will
continued.
be, otherwise I would have got back to the principal bench, my lord,
Will you come? You can appear virtually. I'll write you
virtually
permission.
as well. Very well, my lord, I'll try to, I'll try to be here because, very well.
Day after tomorrow?
Day after tomorrow.
Very. On prayer
Grateful.
of the, you are respondent, all the respondents.
Respondent number, I am appearing on behalf of respondent 1, 2, and 5. And the other respondents are the state.
Respondent, तो
The state, who is appearing? For the state, you are appearing?
Uh.
1, 2, and 5.
1, 2, and 5.
Here
On-
the answering respondent is CGST.
On prayer of respondent numbers 1, 2, and 5, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd July, day after tomorrow.
2nd July.
2nd July, lord.
Grateful, man.
Next,
2nd August.
2nd August.
2nd August.
Next,
For the petitioners, my lords. We are taking time, my lords, because Mr. Mujumdar is suffering.
I can.
next week,
No, Wednesday, my lords.
Wednesday, kindly fix, madam.
you are the petition.
Yes, my lords.
On prayer of the petitioner, the matter is adjourned.
My lords, not petitioner, my lords, on their prayer.
Union of
We
India.
are-
You are the Union of India. On
Yes,
prayer of the Union of India, the matter is adjourned. Paragraph,
Kindly
let the matter appear under the same
Wednesday.
heading on second.
Second.
Grateful,
August.
grateful.
Six now, 4.
6,
4.
4.
4.
Huh?
4. ওটাই মেনশনিং ছিল।
কি বললেন?
SGST।
No copy.
Huh?
কত টাকা? 4.
এই দুটো mention is
6 কেন রেখে দিতে?
4 and 5 will be fixed for hearing on Wednesday, I believe.
No, no, my lord, e-mentioning was done, but
No,
this
no,
was
no.
not these matters.
অর্থ
That was e-mentioning number 4 and 5.
কত 1409 আমাকে কপি পাইনি।
Number 10 না, কত কি mention হয়ে গেল?
My lord, in item 4,
Kindly don't take time, please.
no, I have, no copy has been served upon the CGST authority.
Oh,
No, no, it has been.
In item
It has
4,
been, it has been, it has been. I'm here I'm handing over the.
CGST and SGST both are made party.
But anyway, you are not the answering respondent, I'll give you a.
But
copy. I will
without
give you a
copy.
I will give you a copy. Service.
what about the state?
I am for the state.
You have received copy.
Yes.
My lord, here what has happened,
He has not received copy, sir. Please serve.
My lord, I have already served. I've handed over the affidavit of service, lordship. A long time ago it has been served. And I will give another copy, and he is not the answering respondent at all, my lord. Ultimately, he will take the plea that to expunge his name.
Your respondent number?
I don't know.
He is respondent number, but I'm telling.
No copy has
He-
been served.
বলছি তো আমি। He is respondent number 4.
CGST 4.
Commissioner of Central Books, yes,
You
only
know,
4. Only he is 4, my lord. He's just made a party as a cursor. Since they are sharing the load. My grievance is against the state authorities, and they are the answering respondents.
It shows that it has been served here.
Yes.
It shows it has
So-
been served.
Let me check kindly, fix day after tomorrow.
My lord, he is not even the answering respondent, my lord.
He needs to say that.
My lord, my
Please,
prayer,
why
lordship,
don't you
kindly.
make over another copy to?
Yes, I can, I will.
Please do that.
I
Please
will.
do that. Come back day after tomorrow. You have other matters on day after tomorrow.
Then kindly make it on Thursday.
My lord, not on Thursday, lordship. Kindly makes it on day after tomorrow. আর কতদিন রাখবেন আমায়?
We would love to.
কতদিন থাক না।
এখন তো থাকতে হবে।
It's from the principal bench, so he has. to go.
We understand also, but when because we have the other matters in fixed on Wednesday. It's going to be the predicament from blood on Wednesday. Finally, can we taking a prayer for Thursday? Thursday or Friday at your lordship. He may weekend, he may spend here.
Yes. Now it's
My
your
lord,
choice.
the other matter has been fixed on day after tomorrow.
Yes.
So can it be placed on Thursday again?
Very.
Yes, that will be better.
On prayer of the fourth respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on Thursday. Thursday, it's no?
ঠিক আছে, ঠিক আছে।
না না
ঠিক আছে, ঠিক আছে, থাকবো।
Yes, 3rd August.
থাকবেন তো?
Affidavit of service.
Grateful.
ঠিক আছে, second হবে। এই 500 বার নিয়ে second হবে করবো। First হবে না, ঠিক আছে, ঠিক আছে।
Grateful.
Grateful.
My lord, item number 5, same. 5 to 6. My lord, affidavit of service may be taken on record.
Yes. Who is appearing in 5?
I am for the state level.
Only the state or the CGST is also there?
ওটা না, sorry, ভুল দিয়েছি।
5 and 6.
Yes, who is appearing for CGST?
Yes, I am appearing.
Oh, if he is appearing, have you got this?
Item number 5.
Huh? Copy পেয়েছো?
Yes, item number 5.
So we can take up the matter today?
Yes, it can be taken up.
Yes.
Yes.
আচ্ছা, একসাথে analogous matter.
Analogous, my lord,
Analogous,
all
I think-
3 are analogous matters.
The returnable date is also it is on 7.
4, 5 and 6 are analogous.
Analogous
matters.
matters.
So come back on the same day in that. case.
Lord, he has the copy.
No, for
I can
5 and
move
6.
only
The
one and
state
get.
doesn't have instructions.
So the returnable date is on 7 on the petition.
Oh. Yes, to be listed on 7. You want to come back on 7?
No, no, no.
Thursday? Yes,
These are the matters belongs all the analogous.
yes.
One matter is Thursday belongs, the rest matters can.
Yes.
Returnable date is fixed.
So let the matters appear on Thursday. Yes, because the first matter is fixed on Thursday.
Yes.
So why don't you come back on Thursday? On
Grateful.
prayer of the state respondents, the matter is adjourned. Paragraph of affidavit of service. Affidavit of service on prayer of the state respondents, the matter is adjourned. The matter appear under the same heading on 3rd August.
3rd August. Grateful.
My lord, the affidavit of service has been given.
In
Here.
5.
In 5, 4, 5, I've given in both the matters.
6.
6 ডাকেনি। 6 also I've given, my lord.
I'm passing the same order.
Huh. And this is 6.
6 is same order. Same order.
Grateful.
এটা আছে না, এটা আপনার সাথে 8 আছে।
No, complete. Grateful. my lord.
Respondent number.
Yes, who is appearing in item 7?
7, my lord, I am for the petitioner, my lord. I am joining virtually. My junior will hand over the affidavit of service, my lord. My lord, I am appearing for the petitioner, my lord.
Yes.
My lord, the petitioner before your lordship, my lord, is a librarian who superannuated on 31st of January,
Give me a
2022, my
minute,
lord.
please. Who is appearing for the respondents?
Respondents, 7 number, 7 number, respondents.
Item 7, respondents. Mr. Shah, you are appearing. Crossover will not be possible.
But the service is complete, my lord.
Yes, no, he is representing.
Yeah.
He needs a passover. Shall we start, Mr. Shah? Passover is difficult, I think not today. Not today.
Not to my day after tomorrow, my lord.
Very well, very well.
Day after tomorrow. My lord, let the affidavit of service be kept with the record,
Yes,
my lord,
yes,
because
sure.
my junior will be coming back to
Yes, yes,
Calcutta.
absolutely. Affidavit of service. For paragraph on prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on day after is second August.
Second. I'm grateful.
My lordship, I am for the petitioner. Kindly adjourn the matter for the day after tomorrow, ma'am.
All matters cannot be taken today after tomorrow, I'm sorry.
Lordship, in this matter, Mr. Sandeep Choraria is appearing, he will be physically present before your lordship.
See tomorrow and day after tomorrow.
Yes, Lordship, kindly make it not today then, your lordship. On to accommodation.
My lord, I have received the writ and I am appearing on behalf of CGST department.
Yes.
My humble submission is that this matter may kindly be fixed also on Thursday, that is 3rd. It will be
Thursday
better
we
for
only
me.
Deal with CGST, nothing else.
Only
Yes.
CGST
Yes, my
matter.
lordship.
Will you come back on Thursday?
Okay, my lordship.
Either
Why?
Thursday or next week. Either
No,
Thursday or next week.
Thursday.
Yes.
Kindly keep it on Thursday.
Let us see how far we can. By consent of the parties, let the matter appear under the same heading on 3rd August.
Third. Grateful. Respondent. All respondent. Item number 8.
Nine lordship, on behalf of the learned advocate for the petitioner, I am praying for only for not today. He got stuck on the road, lordship, for some jam.
Number 9, my lord, I for the private respondent.
Yes.
Copy has not been given to me.
But then how come you know that you are appearing?
Where is your affidavit of service?
He got stuck on the road, lordship.
What is the matter about?
Matter, lordship, what I have been informed is that the petitioner, he runs an IVF infertility and research center. Now the patients there come for conceiving babies, lordship, through IVF system. Now the private respondent, his wife was a patient of this institute, and subsequently a baby was born, a healthy baby was born, but unfortunately some mishap had taken place. Now, pursuant to a complaint lodged by him, the CMOH, the Chief Medical Officer of Health, Darjeeling, he passed a prohibitory order directing my institution to remain shut or not to treat patients till the pendency of an inquiry. Now, lordship, the act envisages that an inquiry should be conducted within 7 days. But today we are standing before your lordship after 7 months. Till 7 months, no inquiry report, nothing. And moreover, the act also states that a prohibitory order can be passed only when I am found guilty. Here, during the pendency of the inquiry, and the act also says that an opportunity of hearing, a show cause and opportunity of hearing should be given. Without
when will you come back?
Tomorrow,
may I tell you, my lord? Lordship,
Because the private petitioner is not ready, private respondent has not received a copy. So when do you intend to come back?
Tomorrow, lordship.
Tomorrow?
Copy be given.
I have no problem, lordship. Again, my learned private respondent will say, just today I have received a copy. I'll
Absolutely.
You be ready, come back so that the time should not be wasted.
Next Monday?
Next Monday, yes,
Next Monday?
Copy be given.
Give him a copy in the meeting. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on next one, the 7th August.
7th August.
Item number 10, I got the petitioner, I have started, but after filing this application, some development took place. Kindly keep the matter on 8, so that I can take the instruction. Kindly after 8.
Where is your service? Please serve in the meantime.
I have started, always started, every service is not immediate. Kindly make it, 8, I will do it.
8th,
Yes,
on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8th August.
Lordship, I am praying for 1 week accommodation.
I'm for the state, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 7th August.
8 August, ma'am.
8th August.
Yes,
Lordship.
Your Lordship, I am for the petitioner. I am filing affidavit of service.
Who is appearing
Yes,
for the
I'm appearing
respondent?
for Shri Municipal Court.
There is a private respondent also.
Your Lordship,
Shobhan Shah has served.
twice I have tried to serve upon the private respondent, Your Lordship. Twice it has been written back that there is no person in the said address.
No such person in the address, yes.
Twice, Your Lordship.
You have to find out his address.
Your Lordship, this is the address, exact address, Your Lordship. Kindly see the
If
address.
you have impleted him, you need to serve.
Then our
Isn't it?
direction we pass to serve through local PS, Your Lordship, because I have served
No,
twice.
no. Cannot be.
They are refusing, Your Lordship.
They are not refusing. Refusal is good service. That would have helped you if they would have
But
refused, isn't it?
Kindly see the address, Your Lordship. Our detailed address I've given the phone number also, Your Lordship.
You are sending to the same address.
No, Your Lordship. One detailed address I have sent. Kindly see, Your Lordship. I've given the phone number also.
The address is the same, only little detail, isn't it?
Yes.
So if his first letter says he doesn't reside there, how do you send the same thing to the other, to the
He
same
resides
address?
there only. This is the case, Your Lordship.
I'm afraid you have to serve and come back, sir. I'll give you a week's time.
Again, it will be written same, Your Lordship.
Can't help you to, either you have to expunge his name if he's not a necessary party.
He is
or
a
to
necessary,
serve.
he is a necessary point.
He is a necessary
has-
party.
Because there are complaints against him that he is making unauthorized constructions.
He has already made illegal construction. My representation only to consider, Your Lordship.
Whatever it is, you have to serve first, sir, and then come back.
And through alternative.
If this is
service.
not, you have to pray for substituted service in that case?
Yes.
Yes? Affidavit of service?
Your Lordship, I will serve through WhatsApp, Your Lordship.
No. Is that an accepted mode? How do you make such submissions, sir? Since service upon the private respondent is not complete, comma, let the matter stand over till 9th August? Or you
9th
need little more time?
9th August.
9th August. Noted, no?
If you cannot serve in the ordinary manner, you have to pray for substituted service in that case,
Yes.
45 rule 20,
Yes, Your Lordship.
yes? এটা ফেরত দিবি না।
Twice I have served.
That's why you substitute service day now. Publication of substitute service day.
Next,
Item number 13, kindly fix on 9th.
yes,
I have to serve.
not served.
Fine.
Since service upon the respondents is not complete, let the matter stand over till 10th.
I beg to appear on behalf of the petitioner.
I'm for the state lordship in this matter.
Lord, the petitioner is an old lady living in a petitioner is the old lady living in the remote place in the hills in the Gayabari Gram Panchayat, district Darjeeling, my lord. Now, my lord, petitioner became the owner of the said property by virtue of registered deed of convenience dated 24 December 1992. My lord, since then the petitioner has been enjoying peaceful possession in the said property.
Have you served the panchayat?
Yes, my lord. The answer
Where is the
is
service?
Lord, due to massive landslide occurred in the hills, my lord, the entire property is prone to very rainfall and massive landslide. Due to massive landslide occurred in the near the house of the petitioner, entire
Yes.
guard wall supporting the house of the petitioner was washed down due to rain. The petitioner along with the children are facing tremendous difficulties and inconvenience to live in the residence as there is a serious and inevitable cause of apprehension of collapse of the entire house of the petitioner during monsoon and heavy incessant rainfall with the loss of life as well. The petitioner's house is now standing upon only 2 lean poles. I have annexed the photographs, my lord. Kindly takes up page 18, annexure P2. This is the condition of the house, my lord. 18 and 19, my lord. My lord, after the said disaster, there was an initiative from the office of the respondent number 2 to 4 to construct the guard wall supporting the house of the petitioner, but it was abandoned due to in the midway due to the reasons best known to them. Unless the guard wall is constructed, the petitioner cannot repair the damaged part of the house. My only prayer before your lordship is to construct the guard wall.
It is the order for construction of guard wall. A
Lord?
decision was taken by the panchayat.
Yes, there was
There is that decision.
my lord, decision was not there. There was initiative. My lord, it was abandoned due to midway. After that, I made representation at page 20. My lord, kindly takes up annexure P3.
Yes.
Second paragraph. Sir, you are aware of the fact that the disaster and massive landslide entire guard wall supporting my house was washed down. And the house is now standing only upon 2 wooden stands. There was some initiative from your good office to raise Pakka guard wall so that I may cement a brick and straighten my house. But it was abandoned due to reasons unknown to me. I humbly request the ensuing monsoon season. There is greater danger of entire house being reached down in rain. We will be facing menace of losing our lives, my lord. My entire life is family life is a danger, my lord.
You are asking for construction of the guard
My
wall.
lord, a direction upon the PDO and HDO to construct a guard wall. Rest, my lord, I shall construct the house, my lord, so that I can construct. Unless the guard wall,
Yes.
every
So
time
in this
it
matter-
is washed down in the rain.
Lordship, they did not make any representation before the BDO, neither the SDO lordship.
Who should construct the guard wall? The SDO?
Lordship, no, actually they made the representation before the Pradhan. Pradhan is the main answering respondent in this matter, lordship. So they have the separate advocate lordship in this matter. It can be, representation can be considered with the reason order passed by passing the reason order lordship.
With
This
that help,
presentation was
your-
copied to page number 21.
is the
copied to
Pradhan duty bound to do
Yes, my
it?
lord.
Who
And
has to do it?
above Pradhan, SDO and BDO is
But
the
don't-
authority, my lord.
Uh,
Let the
Let
SDO
him
consider the
file a representation before the SDO.
Yes, lordship.
Let the SDO consider the subdivision laws.
Consider the representation to within a stipulated
In
period of
accordance with
time.
law, lordship.
Please
because the-
file a comprehensive representation before the SDO within 7 days.
My lord,
Let the SDO consider within 2 weeks thereafter.
my lord.
It
And
is a
Lord,
serious matter.
Considering the urgency, my lord, due to rainfall, my lord, my entire life along the locality.
I understand. So 1 week and 2 weeks, right?
My lord.
At the same time, it is having copy of
To the state is a party
It is a party.
and state is appearing.
Yes, my lord.
Affidavit of service. None appears for the 4th respondent despite service. Paragraph. The petitioner claims to be an old ailing lady and acquired title in respect of the property in question by virtue of a deed of conveyance executed by the government by a deed of conveyance executed by deed of conveyance executed on 24th December 1992, and her name has been accordingly mutated in respect of the same. Stop. The petitioner submits that due to torrential rain and massive landslide, the guard wall which supports the house of the petitioner has collapsed, thereby leaving the house at a precarious state. Stop. The Panchayat authorities, they started construction.
Yes, my lord, but it was abandoned in the midway.
Started construction of the guard wall, but such construction was abandoned in the midway due to reasons best known to them. Stop. The petitioner seeks to submit a representation ventilating her grievance before the concerned authority and prays for a direction upon the authority to consider her representation at the earliest, since delay in construction of the guard wall shall result in collapse of her house, thereby endangering life and property. Stop. Paragraph. Learned counsel for the state respondents submits that the second respondent, SDO, that the second respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the second respondent within 7 days from date.
My lord.
Stop. The second respondent is directed to consider and dispose of the representation within 2 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Deeply obliged, my lord.
Next. Not today.
So this matter can be disposed of, nothing remains in the petition.
My lord, I appear for the private respondent, my lord.
Yes.
I've been instructed over telephone to appear. It will be Lordship's pleasure to take it up on Thursday, my lord, because I have yet to get the instructions.
Very good. Come back on Thursday.
Great.
Thursday. By consent.
By consent.
By consent of the parties, let the matter appear under the same heading on 3rd August. Thursday is 3rd.
I am for the petition, Lordship.
State.
I'm for the state. Lordship, I'm praying for an interim relief in for a limited issue. Basically, this matter is squarely covered by the order of coordinate bench. I want to place that on record, Lordship.
What is the matter about?
The matter is about there was a advertisement for granting of license of
Have you served the
FPS.
private respondent? Where is your service upon the private respondent?
Yeah, I have served the private respondent.
Where is your service?
The
affidavit?
Affidavit, I'll just file in the due course of the day, Lordship.
I have to see the affidavit before hearing.
Maybe get tomorrow.
But
I'll
this
file.
becomes a ground for appeal otherwise. Not today?
Not.
Please ensure service. Next.
My lord, one senior counsel will do the hearing in this matter. Kindly fix this on 8th.
Very well. State, you're appearing?
Yes.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same hearing on 8th August.
My lord, I am on behalf of the petitioner. This is the affidavit.
Which matter?
18.
Not called. Give them a minute.
I'm going to state my lord.
Yes, who is appearing for the respondents? You're appearing? Private respondent
Service have been made, ma'am.
affected?
Yes, ma'am.
Yes, sir.
Ma'am. The petitioner hearing is a senior citizen, aged 74 years. Now, my lord, after his retirement, he was staying in Merrick, have constructed a house in which he has also was running a hotel. Now, the OP number 2 is a daughter-in-law. Now, she was married to the son of the petitioner in the year 2012.
OP number 2?
Yes, the daughter-in-law.
2 is the
Oh, OP
subdivision.
number 2 is not the OP number 7, my lord. Sorry.
Yes.
Respondent number 7.
Please do not make the subdivisional officer the daughter-in-law. Yes.
Respondent number 7, my lord.
Yes.
Now, my lord, she was married to the son of the petitioner and she was staying in Sikkim now. Now, what happened in the year 2019? The son of the petitioner was diagnosed with kidney problem. Hence, he had to leave his job. At the end of 2020, they started staying with the petitioner and his wife in Merrick. They shifted from Sikkim to Merrick. And thereafter, the problem started, my lord. The daughter-in-law took over the business of the petitioner because he was busy behind the treatment of his son. And she did not allow him to look into the business and also tortured him. And hence, he filed a complaint before the SDU. And a 107 case was initiated. Now, my lord, the page page 30, my lord.
30, 30?
30.
Yes.
Yes. Page 30 clearly depicts the fact, the tortures which the petitioner have gone through, recorded by the executive magistrate. Now, it clearly says that I have collected some papers from Rajia Pradhan and Shanta Prakash Rai, who's the petitioner hearing, about the medical treatment expenses there too. I have found that this expenses, the management of treatment of Ananta Prakash Rai, the son, is being borne by his parents. The first party, Binita Rai, is his wife. But from 25th April, she is not residing with her husband and not aware about the present health status of the husband. Annapurna Hotel at Krishnanagar is family property of Shanta Prakash Rai. The trade license issued by local municipal corporation, authority is in his name. The municipal tax is borne by Shanta Prakash Rai. The electric meter is in the name of the Shanta Prakash Rai and his elder brother led DP Rai. The property is recorded in the name of Shanta Prakash Rai. I have found that Umita Rai is the sister of the wife of Ananta Prakash Rai. She is married to one police staff of Sikkim. She is a voter of Sikkim. She is residing at Merrick at her sister's matrimonial property since last 5 months. I have found that Anta Prakash Rai is terminally ill and his parents are doing all the duties as family guardian. I have found Vinita Rai is not in touch with her husband for more than a month. And she was told to furnish the peacekeeping bond, my lord.
Yes.
Thereafter, the son died, my lord. After the death of the son, 498 case was lodged by the OP number 7, the respondent number 7. The FIR is in page number 41.
Yes.
Fearing a police arrest, my lord, the petitioner and his wife ran away from their house and they started staying with their daughter in Siliguri. Now, after taking bail, when they tried to enter their own house, the daughter-in-law did not allow them. Hence, they lodged a complaint to the officer in charge, which is in page number 43, annexure P7.
Yes.
But police did not help them. So a complaint was also given to the SP. The postal receipt of the same is annexed in page number 44.
Yes.
And in page number 45, the petitioner hearing gave a representation to again to the SDO, praying that senior citizen case may be initiated, and but nothing has been done to it, my lord. And after the filing of the writ, my lord, the SDO had called the petitioner hearing and have told him to submit the relief he wants before the SDO, in spite of the fact of clear representation has been given to him that what relief he wants, my lord.
That's all your case,
my lord.
Yes.
My lord, their prayer is they have two prayers. First is to take their trade license to restore their trade license, but that is for the municipality to do. For the first prayer, my lord, on page 17. But they want a case to be started under the Senior Citizenship Act.
Yes.
This presentation that is on page 45 to the SDO, that may be considered, my lord, then if the case is to be started. Yes, they have to make an application to the SDO for starting on the case.
This is the application.
This is a representation, my lord. Yes,
So can't the case be started on the basis of this representation?
Yes, my lord. If my lord directs, my lord will start it. Considering all the aspects, probably there is since it is a civil dispute, there is a case pending in the lower court too, regarding the civil dispute.
498A should be pending.
Civil case.
My lord, the
civil case is also pending?
Yes, my lord. The daughter-in-law have filed a civil case not to dispossess her from the suit property. That, but we are not alleging anything in that regard, my lord. We are just saying let the parents, the person who is the owner of the house, stay in that house. With the police protection, he may be restored.
Where are your documents prima facie suggesting ownership?
My lord. Page number 21. Khatian.
Yes.
The page number 22. The revenue.
This is a declaration made by you.
Which one, my lord? Page number
Page 22 is a declaration made by you.
That's a amount. Oh, yes. Yes, yes, my lord. And page number 23 is the holding number. Page number 24 is property tax bill.
She has admitted the ownership, the title in her complaint.
Yes.
So that's not in dispute at all.
No, my lord.
So let your representation be considered within 2 weeks.
My lord, and they be reinstated in their house, my lord. With police protection, my lord.
After hearing both of them.
After hearing, if the
My lord,
authority-
that is very important, my lord. I have a judgment to that score also. It's a Kolkata High Court judgment, my lord.
let the authority take steps for reinstatement.
No, no.
Because admittedly it is their house. There is no if to it.
Yes, madam.
Admittedly, my lord, unless it is maybe a dispute in the civil court, my lord, it is already a subjudice matter in the.
What is the
Their
dispute?
old age, my.
There is a title suit pending, my lord. regarding
Title
the property
suit?
dispute.
Is it a title suit?
No,
or
it is
a
not a title
declaration?
suit. She has.
Do you have a copy of the plaint?
No, plaintiff copy.
Plaintiff copy to me.
No, let the SDO
You're a party to the suit.
Yes, my lord. I am a party to this.
So in the 498A complaint, the daughter-in-law has admitted ownership. So if that be so, they have the right to be reinstated.
My lord.
I do not know what the title suit is about. If you can give me.
My
a
lord,
copy of the
not to evict her
plaint.
without due process of law. What else she will file, my lord?
No, that is your submission. I want to see the plain.
That's what I'm
If I have-
consider all these aspects, my lord, give reason hearing both the parties. If they are in the favorable condition and found that it's their property, my lord, then registration order may be passed.
Can you come back with the copy tomorrow and
My
make it
lord, I
not
have
today only? You have it?
This is the one.
Get a copy, extra copy.
It's nice to name.
He's claiming physical possession. No ownership dispute.
My lord, my personal spirit.
Affidavit of service. Paragraph, none appears for the private respondent despite service. Paragraph. It is contended on behalf of the petitioner that the seventh respondent is the daughter-in-law of the petitioner who initially resided in Sikkim with her husband and shifted to the premises in question belonging to the petitioner after the petitioner's son was diagnosed with kidney ailments.
Kidney ailments, madam.
With kidney ailments. Stop. Since the petitioner was busy with the treatment of his son, he entrusted the seventh respondent, who is his daughter-in-law, to look after the business, look after the hotel business. It's a hotel business.
Yes, ma'am.
Run by the petitioner. Stop. The petitioner's son expired, following which the seventh respondent has ousted the petitioner and his wife.
Yes, ma'am.
Petitioner and his wife from their property and has been occupying the property as well as the business. Stop. The petitioner having no alternative residence,
Took shelter.
daughter's house. Applied before the executive magistrate.
My lord, that was done before the death of the son, my lord.
Where is the application, the complaint?
The complaint is in page number 45.
Equivalent sentence. So they were driven out during lifetime of the husband.
No, after the death of the son, she filed a 498A case, and thereafter suo motu left the house fearing an arrest of the police. And thereafter, when they tried to enter their house, they were restrained from entering their own house, and hence they lodged an FIR, which is in page number 43.
Following next part. The petitioner's son expired rejected. Sentence. Following which, the following which, the seventh respondent lodged a complaint against the petitioner and his wife under section 498A of the code. Stop. The petitioner was restrained from entering into his house by the seventh respondent and was constrained to take shelter
In his daughter's house.
in his
Daughter's house at
in
Siliguri.
his daughter's house. Stop. The petitioner submitted a representation before the subdivisional officer, Merik, requesting assistance to re-enter his house
And also
along with his wife.
representation was given to the police also. That is in page number 43.
Representation to the subdivisional officer as well as the police authority. Requesting and staying there peacefully. Stop. The representations are yet to be considered. Stop. The petitioner prays for a direction upon the concerned authority to consider the representation submitted by the petitioner and render necessary assistance so that he is able to enter into his house and reside therein peacefully. Paragraph. It is submitted on behalf of the state respondents that the second respondent be directed, the SDO.
Not the
SDO.
The second respondent be
okay.
directed to consider the representation in accordance with law. Paragraph. It is not in dispute that the property in question as well as the business run therein are in the name of the petitioner, who is the father-in-law of the seventh respondent. Stop. The petitioner appears to have been ousted from his own property by his daughter-in-law. Stop. The seventh respondent has filed a title suit before the this is Civil Judge Senior Division, Karsiong, before the learned Civil Judge within bracket Senior Division, bracket closed, comma, Karsiong. Praying for a declaration to the effect that she is in possession of the property in question and an injunction restraining the defendants therein within bracket. Defendant number 1 being the petitioner in the writ petition, bracket closed, from disturbing her peaceful running of the business therein and from alienating the property. Paragraph. Upon consideration of the submission made on behalf of the parties and material on record, comma, this court is inclined to hold that since it is not in dispute that the property in question belongs to the petitioner and is in possession of the private respondent, seventh respondent at present, comma, the concerned authority, comma, being the second respondent herein, be directed to consider the representation submitted by the petitioner and take necessary steps for his re-entry into the property. Paragraph. Accordingly, the writ petition is disposed of, directing
Re-entry
the
the house matter in his house
Yes.
at Mirik,
re-entry into his house.
his house at Mirik.
Property na kore house at Mirik. House at Mirik. Paragraph. Accordingly, Mirik. Accordingly, the writ petition is disposed of, paragraph 4, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated. What is the date of your representation?
My lord. It's
3rd July.
yes, my lord.
Yes.
3rd July 2023.
3rd July 2023. Within 2 weeks from the date of communication of this order.
My lord.
And take necessary steps for re-entry of the petitioner and his wife into the property belonging to the petitioner. Within a week thereafter. Stop. The concerned authority shall grant reasonable opportunity of hearing to all the interested persons, including the petitioner, in disposing, in dealing with the representation. Representation in accordance with law. Paragraph. Disposed of.
Great.
My lord, I'm for the petition.
Try for the respondent number 1. This way.
Petitioner,
My lord, I'm for the petitions. May I, my lord?
respondent, you're.
I'm for the respondent.
Yes.
All respondents are here, my lord. My lord, in the year 1999, petitioner bought the ground floor of a two-story building for the purpose of running medicine.
Give me a minute. Who is appearing for the private respondent?
I'm for the private person.
Oh, and the other respondent, municipality?
I'm appearing for the board.
You're appearing for?
Siliguri Municipal Board. I'm for the state respondent.
Very.
My lord, in the year 1999, the petitioner bought the ground floor of a two-story building. In the year 1999, it was two-story building, my lord. Thereafter, my lord, for the purpose of running business of medicine, which is generic medicine in entire North Bengal. My lord, thereafter, they applied for the certificate of enlistment in the year 1999 with the copy of this deed before the Siliguri Municipal Corporation. My lord, they issued the copy, the license to conduct the trade. All of a sudden, my lord, in the year 2022, we received a notice that we are conducting unauthorized business in the said premises because the premises is residential in nature, and since it's a commercial business, so I cannot pursue that. Moreover, it was contended that there are some unauthorized construction in the said premises. Now, my lord, in that factual effect, I submitted 2 letters before the SMC. First one was that, my lord, the construction which was done, it was done by another occupier or the owner of the said building, because the original owner who sold he sold that building as a flat, the ground floor to us and this first floor to another.
So you
person.
purchased only the ground floor?
I purchased only the ground floor. Now the owner of the first floor, he somehow managed to obtain a revised building plan from Siliguri Municipal Corporation without intimating us or without taking any NOC or consent from us. In that revised plan, my lord, he has taken the consent for construction of another floor and also some other construction work. Now, every time they are sending us notice stating that you are doing illegal construction in your property. But I am telling that it is not done by me. I am only owner of this ground floor and not the owner of the first floor or the second floor or the rooftop, nothing. And the backyard, all the construction made in the backyard. I am only concerned with the 1998 building plan. According to that, I purchased and I am staying there since 1999. He came in the year 2004. In 2006, he somehow obtained that revised building plan in the name of previous owner. He sold entire property. How could he obtain that revised building plan? I have no idea.
Where is the impugned order?
My lord, the impugned order is at page 86, P16, my lord, annex of P16. Thereafter, I filed a writ petition. Direction was given upon them to conduct hearing, my lord. They fixed a date for hearing. I was present, the petitioner was present, but since the private respondent was not present, the matter was deferred. The date was deferred. All of a sudden, on 6/7/2023, I found that they have issued this order stating that hearing has been concluded. And all the time the inspection which was made, they are placing that same, the inspection team, he is placing the same replica of the earlier inspection, stating that I am storing the medicines in my garage. I have placed all the documents in that regard, the photographs of the entire building, the photographs of my garage. My lord will find that it is used only solely for the purpose of parking bikes and cycles. Apart from that, nothing. No storage has been done. For one day, some cartoons were kept because that is accepted fact. I have accepted before them also that some cartoons were kept due to construction work inside my premises. For that reason, for one day, some cartoons were kept there. Apart from that, never any storage or dumping has been done in that premises. Moreover, my lord, my condition is that I have applied for conversion also. After knowing the fact that since
it's a residential premises.
Residential premises, that too, my lord, the nature was changed in the revised building plan of 2006, which was not in my knowledge. Because when I applied for the enlistment, I provided the deed of my purchase, the deed of conveyance, and my deed of conveyance, it is specifically mentioned that for purpose of running the medicine retailership, I am purchasing this property. That is written in my deed of conveyance. If my lord could see page number
2. Your application for conversion is pending.
My lord, no, they have in this order, my lord, they have disposed of. They are stating that I am not eligible for the conversion because since 1999, I did not apply for conversion. Only after knowing the fact that I need to take license for commercial activity, I have placed before the authority a fresh application. this is, I am, in my contestation, my lord, I would like to state that on 25th, they have issued us a notice. On 27, without wasting any time, further time, I have placed a application for conversion. And in my letter of conversion, I have specifically mentioned that at any condition, even if I have to pay the fines from penalty from 1999, I am ready to pay. I am ready to pay that. No, in this writ petition, I am
Allegation against you is not unauthorized construction, it's unauthorized use.
no, my
You're
lord.
using it for commercial purpose, that is the allegation.
No, no, there are other allegations, my lord. Can you see the notice, my lord? The notice dated 25th of page 43, my lord.
They say you are using the open space as a garage.
Yes.
My lord, that is a covered garage, my lord.
There is your deed.
My lord. At page 28, my lord.
Please show me the relevant portion where you are allowed to carry on commercial activities.
Yes, my lord.
The recital will not do, it has to tally with the schedule, my lord.
Yes.
Yes, if you also kindly come to the internal page 10. The vacant passage, front side of the building about such length, vacant passage north
Page
side of
10
the
of-
building. The page 10 internal of the deed.
No page number is there.
Vacant passage south side of the building shall be used exclusively to the purchaser. Staircase of the building shall be used exclusively to the vendor. Number E, bathroom, urinal, latrine, ring well, tubewell, meter standing. Now, if you kindly come to
Let him complete, let him point out the garage in the deed. Yes,
My lord, in the that building plan of 1998 is not available.
there
with
are
me.
twofold allegations against you. One
My
is
lord.
you have covered a vacant passage and you're using it as a garage.
My lord,
Secondly, you're carrying on commercial
my lord. In that regard,
activities.
my lord, if they provide the building plan, my lord, as Siliguri municipal plan, I can show that.
Building plan should be with you, with your deed.
No, my lord, the building plan was not with us. The land plan is with me, which I have annexed, my lord. The land plan is with me, but the building plan was not handed over to me, my lord. The land plan is at 40, my lord, page 40.
Where does your deed refer to the commercial activities?
Yes, my lord.
Now, you will also kindly come to the schedule of the property.
I've seen that.
It's exclusively the residential thing. Now, before Lordship kindly comes to the notice dated 25th May 2022. This notice is issued by the Commissioner Civil Municipal Corporation. When he has been pointed out that you cannot carry on commercial activities in a residential building without prior permission. Lordship, thereafter, only after being pointed out.
He has applied for conversion.
He has applied for conversion.
Where is the document?
Yes.
The letter, the notice?
Page P4, my reputation has not been designated. P4, P4 for page number.
P4 is 43.
Yes, P4 25th May 2022. Now it has come to the notice of Siliguri Municipal Corporation. Now this activity was undertaken pursuant to a complaint lodged by the private respondent. It has come to the notice of Siliguri Municipal Corporation and also as per report submitted by the technical officials of this office that commercial activities being carried out at your premises which is residential in nature as per revised building plan such and such. You are therefore directed to appear before the undersigned in the presence of the officials of the building
Yes.
section of the corporation. Now, Lordship, they have obtained a license for running a medicine shop. And in the garb of a license for medicine shop, they have converted it into a wholesale trade, wholesale business. Now, your Lordship can.
No, my lord.
Can
This is
visualize
false, my lord.
from his
Kindly
very
see the-
averments, from his very
kindly-
averments.
First thing, please show me that in your deed it is stated that you can use it for commercial purpose.
Kindly come to page
my
number
lord.
4 of his writ petition, page 4. Page 4, paragraph 3, last line. The petitioner's organization CDMU is carrying the said business of supply of medicines. Supply of medicines means he has to stock the thing to entire North Bengal. Lordship can visualize the amount of the amount of goods that is being stored and supplied to the entire North Bengal.
And he has also carried out structural changes in the ground floor, madam.
He has covered the open area.
Yes, yes.
My lord, those open areas are in the plan, my lord. If they provide the
The open
2006
area
plan, my
is in
lord.
the plan. You have covered it into a garage. You've converted it into. a
No, my
garage.
lord, the garage was present. It was there from the very beginning.
It has to be in your deed. Please show me.
My lord, the site in the
Not
building
necessary.
plan, my lord, it was
There should be
there.
an averment in the deed itself. Where is that?
My lord, in the
The
deed,
garage and the commercial activity. These two averments should be in the deed.
my lord, it
itself.
was there, my lord.
Please show me. Otherwise, you have no case at all. I'm sorry, there is nothing in your deed.
My lord, there is, my lord. Kindly. So, my lord, if my lord give me short password, I may come back. My lord, kindly give me short password, my lord.
How
It
can you
is,
improve your case by a passover, sir? I do not find anything in your deed. I have gone
Lord,
through the deed.
I have read that portion, my lord. And before in their office only, I have read that portion. And he only read for me. Here it is written. So it is there, my lord. अरे last दिन तुम्ही तो पढ़ले बोलो तो अभी
আমি অন্যদিন নিচে দেবো।
It is apparent on the face of record that a residential building has been converted into a commercial work without any permission. It is apparent from his own record.
It is also apparent, my lord,
He
that
cannot
without
bring out a new story.
my signature or consent, how a building plan is
He
changed
has no, he has
by
no,
him,
he has no right even for.
by
the status
him,
of
my
the
lord,
owner.
by forging the signature of the owner.
Malad,
Is
he
that,
has-
is that part of your petition?
No,
Yes, my lord, that is also part of
Malad,
my writ petition,
It
my lord.
also kindly comes to the internal page of the deed, my lord. Paragraph A, he has no, he has even excluded the right from the status also. He has no right over the status also.
There is just one line, page 33, the second paragraph. Suitable for its business purpose. That's all.
In event that has to tally with the schedule, madam. Because he has to pay stamp duty for commercial purpose of them. And it has to
Now-
tally with the sanction plan also.
Now, Lordship, if I may point out Schedule 4A of the Corporation Act, West Bengal Municipal Corporation Act, Lordship. It says that permissible category of business activities of non-residential in nature in residential building. It allows lawyers' chambers, it allows a medicine shops, but there is a restriction to it. Restriction is under C section 273A. 273A says in residential building alongside major roads, the road where this lane, not a major road.
And he's
was the
carrying on a
permission.
business of supply of medicines.
Supply of medicine.
It's not medicine shop.
No, it's not a
Retail shop.
medicine shop. Wholesale business. He's storing medicines there, man. My minor.
A lot of medicine shops also store medicine. Without storing medicine, how they will sell, my lord? If I go to buy a medicine, they will call the retailer and please send me the
Please do
medicine.
not twist the words. Medicine shop is one thing, supply of medicine is another.
My lord,
So please do not do
kindly
that.
see the enlistment, my lord. The certificate of enlistment. I have never mentioned there that it is a shop.
That's the difficulty. A shop was permissible.
Yes.
If it was a shop, it
Shop
was
is
permissible in a residential area unit. Since it
lord.
is not a shop, it's a wholesale business, it is not permissible.
In 1997, my lord, prior to 1993 till 2006, my lord, there was no scope of any medical shop also. Kindly see the West Bengal Municipal Corporation Act 1993, my lord. It was incorporated, this medical shop was incorporated in the year 2006 in their schedule.
Yours is not a shop at all.
My lord, it's a kind of shop, my lord, because their sale and purchase both are going.
Kind of shop and a shop is different.
My
Show
lord,
me documents that it's a shop, it's a medical shop, medicine shop. Do you have any documents to prove that? I'm sorry,
what
sir,
document
it's-
can be
I
provided
don't
in
think
that
we
regard, my
should
lord?
spend further time. I have to dismiss
My lord,
this.
kindly, my
nothing.
lord, what document can be, what suitable document will be provided that it can prove that it's a shop?
Your trade license will say it's a medicine
My lord,
shop.
kindly come to my trade license.
Yes, show me your trade license. At page,
Medicine shop की नाम कुछ? नाम क्या?
page,
Page 42, my lord. P3, my lord.
medicine wholesale
Yeah,
business.
Wholesale.
So this is not a shop.
This is not a retail shop.
My lord, the wholesale,
Wholesale business is not a shop, sir, you are aware.
my lord, wholesale business also runs in a shop, my lord.
Means is not important, it's irrelevant.
It's a.
If it is a medicine shop,
My
it
lord,
is
this is
enlisted
a
as a
generic
shop.
medicine, my lord. Generic medicine, my lord, and it's a shop, my lord. Because
The
wholesale,
document
they also,
doesn't say shop. No conversion since 1999 or whenever you have purchased, nothing.
my lord, I was not in a position, it was not known to me that I have to take a separate conversion
Is
from,
ignorance of law a ground, sir?
no, my lord, it's not the
He
ground,
was
my lord,
prepared
but
by a legal
after
expert.
knowing the fact, when I came before them and I accepted my fault, that has to
is-
be considered, my lord.
That is after notice.
Yes, my lord.
And you
because-
were heard when the matter was taken up by the authority?
Yes.
It was
No,
in
but-
your presence?
No, my lord, the matter was kept pending because the respondent number 5 was not present that day. Kindly ask them to produce the attendance sheet.
Respondent number 5 may not have been heard. You were heard by the authority before the
I
order
was
was
heard, my lord,
passed?
but there was a question. Let me first complete. No, my lord, when
Yes, because
the
your
question
contention
was-
is recorded in the order.
my lord, when the question of that revised building plan came, my lord, in that revised building plan, we had no knowledge about that. That there was a building plan prior to my purchase or after my purchase. I only came to know when they sent me the notice stating this, according to this building plan, you have constructed this and that. So I challenge that. I have never obtained any building plan. So when they produced that building plan and the signature, there was some mismatch with the signature. The commissioner himself deferred the matter because he was not present. how he constructed.
How he
Wait,
diluting the matter.
Where you have
diluting the
stated
matter.
this in your writ petition?
Yes, my lord.
Paragraph?
He himself, in paragraph 3, he himself admits, he is a supplier.
আরে কথাটা হচ্ছে বিল্ডিং প্ল্যান।
হ্যাঁ, তোমার কমার্শিয়াল ইউজ নিয়ে তো কথা হচ্ছে। বিল্ডিং প্ল্যান তো পরে আসবে, আগে তোমার ইউসেজ তো।
আরে how you have taken the building plan? When the,
I have the proper document.
how you have
But this is.
place it?
No, this is not.
Place it.
this is
You're not place.
this
You're
is
not
the issue here. This is
Now,
not the issue
you
here.
have recorded 2-story to 3-story, all these are irrelevant in this writ
Well,
petition.
This is
My
not the
lord,
issue
that
here.
is very relevant because they are in the last
Two issues, sir. Firstly, a
trust.
medicine shop or a supply of medicine, and secondly, conversion of an open space into a garage. These are the two issues.
well, open space into garage is in their building plan
The
only.
recent order is not.
In their building plan
Will
only.
you come back at 2 p.m.?
Yes, ma'am.
দুটো সময় লাগবে নিতে পারছি।
My lord.
ওটা দিতে তো। হ্যাঁ, হ্যাঁ।
My lord, in continuation, page number 33, my lord has pinpointed rightly, my lord. Paragraph, second paragraph, my lord. The
That's
building,
just a line.
yes, business. The word business has been used, my lord.
The schedule doesn't say anything. No
My lord,
permission.
My lord, in the body, when it is mentioned that will be for the carrying purpose of business, the word itself business comes, my lord. Page 33, second paragraph.
Purchaser found the property suitable for business. That is neither here nor there, sir. I'm sorry.
My lord, for the purpose of, my lord, now the what my lord has stated, that shop, whether that is wholesale or retailer, that will be cleared, my lord, if my lord goes through West Bengal Shops and Establishment Act. Section 2, subsection 13, my lord. Section 2, subsection 13. My lord, since I have only one copy, can I
Subsection?
13, my lord.
Yes, but it is not shop at all. Where is it stated that it is a shop?
My lord, wholesale business.
That is not a shop.
That
A
decides,
shop
my lord,
includes
wholesale business, my lord.
a shop includes wholesale business, but wholesale business is not necessarily a shop. It is not vice versa.
My lord, if a if a portion of anything, a trade is carried on, my lord, in that portion, that can be termed as a shop only.
Not at all. Not
My
at
lord,
all.
the definition of shop here clearly specifies that what kind of
Shop,
business.
is it shop? Where is it referred as a shop? Please show me.
My lord,
In the deed or in any document, is
My
it
lord,
referred to as a shop?
the business, nature of
Business doesn't mean shop, sir. I'm sorry.
My lord,
And you're repeating your submission, which will really not
my lord,
help you.
may I, my lord? In the trade license, my lord, it is not categorically mentioned about shop or
So this
anything.
definition is not covered.
It is only defined as the nature of business, my lord.
Where is your trade license?
My lord, at page 42, my lord. The nature of business they are stating. So nature of business is wholesale medicine. Now I cannot put their wholesale medicine shop, my lord.
Wholesale medicine is not a shop. A
Lord,
shop
that
may
is the
include
nature of business,
wholesale.
my lord.
Yes. So show me one document that it is a shop, at a medical shop.
My lord, the nature of business
No,
is
no,
done
stop.
in
I'm
that.
sorry. I'm sorry. I'm sorry.
My lord, the definition of shop is given in the establishment, Shops and Establishment Act, my lord.
That doesn't cover your business. I'm sorry, I have to dismiss.
Then, my lord, kindly consider one fact, my lord, that the point where, my lord, they have stated that unauthorized construction, the garage,
Yes.
it was open space and it was changed into a covered garage.
Yes.
My lord, that point, my lord, can be evident only from the revised building plan, my lord. Because in the revised building plan, it has been categorically pointed out that it is a garage, not an open space. That's why I'm asking my lord to give direction to the SMC to produce that site, the building plan.
How do you know that it has been stated as garage in the building plan?
My lord, they have shown me that during the inspection, during the hearing time, they have produced that entire map, building map, my lord. And I have seen their map. That's why I'm asking them that produce that site plan, the building plan. They are suppressing that building plan, my lord. My lord, he has the building plan.
You admit that it has been converted into a garage?
No, my lord, it has been.
So if you are claiming a garage, your deed should depict that.
My lord, can you see
Car parking has been converted into a.
car parking is there, my lord.
Where is your garage in the
It has been
deed?
converted. Has been converted.
It should be stated in your deed.
My lord, At the time of 1998, my lord, when the deed was prepared, that time it was only a balcony. It was only balcony.
The building
Here
plan-
after, my lord, this building plan shows that it has been converted into a garage. It is not my claim. It is their claim only.
The building plan.
It was
shows-
a vacant passage when you purchased.
Yes, my lord. No, no, veranda. It was a balcony.
Page 10 of your deed, page 37 of the writ petition.
One veranda.
My lord, if my lord sees page 40 of my petition,
Vacant passage front side used by the purchaser and vacant passage south side. These are all vacant passages to be
Vacant-
used by you.
they are vacant only.
So where is the garage in your deed?
My lord, page 40, my lord,
Yes. Page
extreme
40.
left side, my lord, at the bottom, veranda written. Page 40, my lord. Extreme,
It is not legible.
My lord, may I? Kindly comes to the second notice dated 26 September 2022. This is the
Page?
Inquiry, second notice after the inquiry. Kindly the third point. It's
At
clear.
page
P7, page number. P7, annexure P7.
P7. Yes, second notice. Yes.
Page 52, that is the third point. It's clear that one number covered car parking and the tenement in the ground floor as per said sanctioned building plan has been converted. It has been converted and rendering commercial activities. It's clear. It has been converted. Car parking has been converted and rendering commercial activities.
my lord,
which is
the
in gross
car
violation of-
parking has never been converted, my lord, nor it is under commercial activities.
Then
Car
These are-
parking,
from the air.
These are disputed questions of fact
This
which
is
the
the inquiry
writ
My lord,
petitioner
because-
cannot decide.
I have enclosed the photograph, my lord.
Evidence is
photograph-
necessary.
My lord, the photograph speaks for itself. Let them produce any photograph that I am doing commercial activity.
Kindly see the photograph, my lord.
Yes, my lord.
Yes.
My last photograph, my lord. Sorry, my lord. Second last photograph. Both are same one. Kindly see, is this a medicine shop, my lord? Kindly see.
Which one?
Kindly see. Second last photograph. Of
Yeah.
the last one.
Stating about garage, my lord, 73, page number 73, my lord.
Community Development Medical
Yes.
Unit.
Medicine unit. This is a medicine shop.
That is the name of the,
Wholesale.
that is the name of the company, my lord.
the
Medical
shop.
unit is the name of the, sir, please.
That is the name of the company, my lord. It's a
The
NGO, my
medicines are
lord.
going to be circulated.
It's a NGO, my lord.
Yeah.
It's a NGO which are running.
I have no other option, sir.
My lord,
I
kindly
cannot
see
give
the,
you a further
my
time.
lord, kindly see page
I have to take up other
73.
matters also.
My lord, kindly see page 73 and 74 and their plan, my lord. It is written there, it's a covered garage. It's a parking space, my lord.
Where is it stated? Covered there, which is the ground?
Yes, my lord.
This is
At the
the
bottom,
ground
my
floor
lord,
plan.
bottom.
And it has been converted into covered garage. Now he is using it as a commercial space, my lord. This is the allegation, my lord.
It is recorded as car parking. It is not a covered garage.
Covered
Yes, my lord.
garage.
And
Now he has covered it. Now he is using as a commercial for his commercial activity.
so that
This is not a
You
covered.
admitted
garage.
that. You admitted that.
Where I have
In your petition.
where I have
you
admitted in my
are-
petition, tell me.
You are telling that you are using it for business.
That
I'm
car
not saying
parking,
that.
that car parking, I have-
Entire portion.
no, no, you are specifically
Entire
stating
portion.
that I am using that garage for car parking. So,
Even-
so many,
Even if we ignored the garage part, you are using the building as a commercial
floor.
unit.
my lord, I am using the building for commercial unit and for that I have made an representation for obtaining the license.
That has been turned down.
Turned down, my lord, on the pretext, what the
So you
pretext
have
was.
to.
My lord,
approach
kindly
the-
see the, then order, my lord, reason order.
Who is the appellate authority for this?
My lord, since
When
the
the
order,
credits turned down?
appellate authority is the High Court, my lord, because the order was passed in pursuance to High Court's direction, my lord. Order was passed due in pursuance to the
Sir,
High
I am
Court.
yet to learn. Any order passed in pursuance of a direction of the High Court, the High Court is the appellate authority. That is your submission.
No, my lord, the mayor is.
Last question. Any person aggrieved by the order of the commissioner, he may prefer an appeal to the mayor.
It's an appellate order.
So I said, my lord, mayor is
Yes, it's an appealable order. So now, next what? We have spent the whole morning on this.
my lord, I am only seeking, my lord, kindly allow
Will you
me.
prefer an appeal?
No, my lord, I am preferring that a fresh inspection may be
Not at
conducted.
all. The order,
Because every time they are sending men who have the nexus with this, they both have nexus, my lord,
two
and they are
options,
doing.
sir. I don't think I can spend further time on this. Two options. You have to either prefer an appeal or your petition gets dismissed.
Then, my lord, allow me liberty to prefer an appeal and come back.
Because your primary prayer is for setting aside the order, isn't it?
Yes,
It's appealable.
my lord, but
Because you were heard. There is no question of violation of natural justice. You were heard. by
my lord,
the court.
I want a interim protection till my appeal has
No,
been
no,
heard, my lord.
Not at all, not at
My
all,
lord, kindly, my lord,
not
what-
at all.
a small,
Illegal things and mirrors.
kindly allow me
Order.
one protection, my lord, any protection, my lord.
Sir, I was about to dismiss your writ petition. Because if I am to deal with it, there is no merit. That's why instead of dismissing it and giving you an opportunity,
My lord.
go before the appellate court. Try your luck there. There is nothing, there is nothing. else. I'm sorry. The order passed by the Commissioner, Siliguri Municipal Corporation on 6 July 2023 is assailed in the writ petition. The said order is amenable to appeal under section 267 of the West Bengal Municipal Corporation Act, 2006. Paragraph in view of the above, the writ petition being WPS such is dismissed as not maintainable. Paragraph, liberty is granted to the petitioner to prefer a statutory appeal against the said order
Within 2 weeks, my lord.
There has been a delay. That has to be
paragraph.
considered.
In the event the petitioner files statutory appeal within 2 weeks from date, the appellate authority shall deal with the appeal on merits without dismissing the same on the ground of limitation. Because he has crossed the limitation.
Yes.
So let it be dealt with on merits.
My lord,
There shall however be no order as to cause urgent certified website copy.
highly obliged.
Next.
Lordship, I am for the petitioner.
Have you served?
Yes, Lordship.
Who is appearing for the state? Mr. Shah, oh, you're appearing, yes. The secretary, Muzaffar Ahmed Memorial Madrasa. Have you served
Lordship.
this person?
Lordship, I have sub all the parties.
He is a private respondent.
No, all at the.
Sixth. No. You're representing the sixth respondent also?
But Madrasa Education Board agreed they have separate set of councils. Respondent number 6 is the secretary.
Secretary of the Madrasa
Shiksha
Shiksha
Kendra.
Kendra.
Yes.
It is a Madrasa Shiksha Kendra. They have
Lordship,
yes, it
may
is
I?
Should be a private respondent.
private respondent.
Have you served the secretary?
I have already served, Lordship. Lordship, respondent number 4 is the performing authority, Lordship. May I, Lordship?
It is served.
Yes.
And you're appearing for all the other respondents?
Well, I'm appealing for the state respondents.
What about the Madrasa Education? West Bengal Board of Madrasa Education.
Madrasa education, I believe they have separate set of councils.
West
as
Bengal
they
Board
have
of
in the
Madrasa
principal
Education.
bench.
Served. If it is served, we can take up that.
Yes, Lordship. So.
Served.
किधर है? माद्रासा को किधर बोला है? तू कितना को बोलते?
Who is the answering respondent?
Yes,
The state?
Respondent number 4, Lordship. Sorry, respondent number 3. West Bengal
Who is the
Board of-
board, my lord?
That's the board.
That's the board.
So can we hear the matter in absence of the board? Who is who
Lordship.
appears generally?
There is a
Okay, board is.
Mr. Hillel.
नहीं.
No, just.
He was here.
Yes, he was there. And make it short faster than.
But he's not there. I'll make it not today only. Yes, will you inform him once? I'll just make it not today.
Calcutta.
Yes, come back tomorrow. Please inform me.
Yes. Lordship, he is here.
Ready?
किधर है?
Well,
Yes.
21, by appeal for the petitioner, my lord. My lord, this is.
Service affected?
Service has, everyone is appearing.
Respondent number 4. Private respondent.
There is only one private respondent is appearing. The corporation is appearing, my lord.
Who is appearing for the corporation? You are appearing. And the private respondent?
I am.
That is 5.
Yes, 5.
Very well. Yes.
Yeah. But the state, may I submit, but state has, I mean, state.
Respondent number 1.
State has, I mean, made a party, but nothing has to, it's only within the corporate.
If you make a party, you have to serve. If the state is made a party, you have to serve,
Yes.
isn't it?
It should. It should, because the service has to be there, because we don't have the affidavit service, that's the only harm. Because since we
State
were-
says they've not received copy.
because this is the third round of litigation, that's it.
Maybe,
State
but
was
you
never
have to
there.
serve and come back.
State was never there. No,
You
Anyway,
ought
we'll
not to
come
have
back.
made
We'll-
party.
Miss a day, circuit. Difficult.
This is the third round here. That's it.
You should
State
have
was never.
served.
We'll,
When you implead someone as a party, the person has to be
Yeah,
served. That's the
definitely,
basic
definitely,
minimum, isn't it?
we'll do.
Since service upon the state is not complete, comma, let the matter stand over till next Monday.
But day after, my lord, this is an order where a demolition notice has been set aside by the High Court earlier. There is a joint inspection report that has been ordered by the High Court. We, by this writ petition, is only seeking for a joint inspection report. Nothing much to be looked.
So day after tomorrow,
Day
you
after
serve in
tomorrow.
course of this.
We
day?
will definitely.
That is second.
Second.
August. So.
That-
Actually, it will be
Then
better if you
fourth
expunge,
August. 4th
Fourth.
August.
Grateful.
if you expunge, if you expunge the name of the state.
Join the-
If you expunge the name of the state, because his state was not, never a party.
You want to
Yes,
expunge?
Yes.
We want to expunge.
Yes,
that. We can,
shall take up.
No, that's the right, you are submitting right.
well, he is submitting rightly, since he's made a party, because that's a fault on our part. my lord.
Yes.
You ought
That's
to
a
have
fault,
served.
that's a fault.
You ought to have
You are
served.
at liberty to expunge.
My lord, we take that liberty, my lord. My lord, if state doesn't mind, my lord, it doesn't take an, as an offense.
No. He wants to expunge the name of the state.
If the state doesn't mind, of course.
No role to play in this, your lordship.
Let him be expunged. If the state is not made a party, then you have no responsibility, isn't it? Or on behalf of the petitioner? The name of the state of West Bengal, comma, being the first respondent hearing, be expunged from the cause title of the writ petition. Stop the cause title, be amended accordingly. Yes.
Well,
now
my
we-
apologies, my lord.
Be beyond merits now, yes.
My lord,
This is, my lord, a second round of litigation where we are a party in the writ petition. My lord, earlier there was one round of litigation that has been gone where we were not a party to it. My lord, before I place facts from the record, my lord, let me just briefly state what has happened. My lord, there is a writ petition has been filed, a complaint has been filed of a 2001 plan alleging a building was complete 20 years, shop rooms were sold, given. Now, after 20 years, a complaint has been filed by someone who is nothing to do with that building, who is supposedly having a dispute with the erstwhile owners of the building. And then it's a payback time for us. It's some of the things that has been made. We'll come to that, Mother. We have because challenge the locus on one part, Mother. Because we have said that its statutory provisions cannot be used as a vehicle for personal vendetta. That is also one part of their own locus. Now there was a complaint filed, an inquiry was lodged. Now, my lord, corporations made an inquiry. Supposedly there was an inquiry. We don't have a report to that effect. But the court passed an order of a demolition on based on a report. A demolition order was passed. Now the landlord, my lord, filed an appeal before the appellate court. The appellate court set aside that order, said that that is not in pursuance to section 287. An opportunity should have been given for hearing. Needless to say, all parties should have been given a hearing. That was the order of the appellate court. Now, the order was set aside, went back. The appellate court had a rider to that. The commissioner can, if required, look into the inspection report that was done. That inspection report was not done in our presence. We don't know the knowledge of the inspection reports. Well, then a hearing was conducted. Again, hearing within corporation and the erstwhile owners and the promoters. The shop owners, more than 20 of shop owners, none of them were given notices. A 287 proceedings was conducted in our absence. 287 proceedings culminated in an order of demolition. Now, the demolition order, at the end of the demolition, it is stated that since this is an order of demolition, we direct that for the purpose of natural justice, all shop owners should be given a notice to it. We file, then we come to the knowledge of the order of demolition. We file a writ petition saying that, look, you are giving me an ex post facto hearing. The court has held that, said that, look, this is no hearing at all. When a court has made up his mind of demolition and then giving a hearing based on an inquiry report where they were never a party to it, this is a bad order, so set aside the demolition order as well. 287 proceedings also set aside. There the court also set aside the inquiry proceedings also, joint inspection report also set aside. Now their complainant filed an appeal before the appellate court there. Now the appellate court said, keeps these single judges order, set aside demolition. Now you have to give hearing to the shop owners. They should be heard, set aside everything, excepting again a rider that the inspection report, since it has been made, let that be there with the inspection report be there for the commissioner to look into the fact, provided that there is again an inspection, joint inspection with the shop owners. This is. So we come back again. We were hoping that a joint inspection will become. Then I will come back. I'll take to the inspection notice that has been. 2/5/2023 is a notice, supposedly a notice, where my lord will find. My lord, it's starts from page 187. This is a notice where the corporation says that it is at page 189, my lord will find. Page 189, my lord will find.
Yes.
On the last point, my lord, that everyone is directed present on the site on 2/5/2023. This is the date that has been fixed for a joint inspection report in presence of our shop owners. The corporation personnel will come. The erstwhile engineer, Mr. Konar. This is the supposed notice. My lord, this notice, my lord, I'll rely on the record of the corporation, was never served upon us. There is, we will not find a single recipient of any of these proposals, never. Anywhere, inspection team comes on 2 seconds. Inspection team comes. Now what happens, inspection team, since the shop owners, we go there. We say that, look, a notice has not been served upon us. The notice has not been served upon us, so why are you doing an inspection? So the corporation there says, then okay, then we'll do a second inspection. Now we'll see at page 179.
Yes.
Yes. This is to inform you that a joint inspection dated 2/5/2023 at 2 p.m. was conducted, wherein some of the owners and occupiers of the subject structures remain absent. But remain absent because the reason why I have said, my lord, to ensure justice to all, it has been decided that once again, a joint inspection report of the existing new building cited so and so will be conducted on 31st March 2000. So the corporation says that there will be a joint inspection on so and so date. Now what happens, my lord? In between, my lord, a report has been filed. This inspection was, this notice was not adhered to, report has been filed. My lord, report has been filed at
This notice was served upon you, the
yes,
second notice
yes,
was served.
yes, yes, sir, served upon. Now from the report has been filed on page 108. We were waiting for the inspection. Before the inspection happens, a report, final report has been filed. Again, without a, from page 180. This
180.
is 180. 180, my lord, will see at paragraph 4. 183, my lord. I'm just trying to revise, but
Were you present when the inspection was held on 31st May?
Yes,
Right.
they were present.
31st May, there was no inspection.
No, but on the second occasion on.
There was
when
no
the
inspection.
was carried on the second.
That is second, that is the
The
case.
second occasion is 31st May.
31st, there was no
They were
inspection.
present, They were present.
There is no inspection at all. This is paragraph 4, my lord, page 183. What this is? This 183, paragraph 4. The Siliguri Borough Corporation sent notice to all parties. Paragraph 4, my lord, has it?
Yes, yes.
Inspection of subject part will be carried on 2/5. Paragraph 4, page 183.
Yes.
On 2/5, this. Paragraph subject on 2/5 in compliance of the High Court order, so and so annexure 1. When after 2/5, the 2/5, there is no inspection. That's the reason the second notice was sent for an inspection. Now, inspection has been report. This report, my lord, will see, will be surprised to find this report, my lord, at paragraph 8, my lord. My lord will see at paragraph 8, page 184. Can I read it, my lord? That's very important. It says, in the above circumstances, the inspection team once again closely reviewed and verified the earlier joint inspection report dated 28/3/2022. This inspection report had been set aside by the single judge. The division bench said, you keep this inspection report, but do an inspection also. The liberty was given to the commissioner to take note of the inspection report, provided there is an inspection in our presence also. There has to be an inspection in our presence. There is no inspection in our presence. This writ petition is only because
you're asking for a fresh
is in our presence. This is only the thing that.
Yes.
Now, may I point out one thing on the lordship? When the inspection was carried out on the second time, when notice was served on all the parties, they were present, and if your lordship kindly read paragraph 6.
6
and 7 of the page number 184. Before the inspection, before the inspection report was published, the inspection team, paragraph number 7. The inspection team then asked the parties present at the site to inform their grievances, correctness, concerns with respect to the earlier joint inspection report dated 28/3/2022.
This is on which date?
This is on 28th. This inspection report was first in the first instance.
When was this? This team went to the parties present. On which date did the team go?
2/5.
2/5. And what does the second notice say? 2/5, everyone was not present? So a second notice was issued.
Second notice.
So how do you connect, how do you
May I, Lordship, may I
get
answer?
incomplete?
Okay.
Your authority says on 2nd May, everyone was not
170.
there.
Act
So you served a second notice fixing 31st May. When you write the report, you say that 2nd May inspection was held and the report was prepared on the basis of the 2nd May inspection, where everyone was not there. How do you reconcile? How do you
Your Lordship, may I submit?
let him complete? Please.
I'll just go through the pages. Let him continue.
Your Lordship, kindly peruse the order passed by the learned single judge, honorable single judge. It is in page 153 to 162. 162, page 162. Page 162, middle portion, Your Lordships.
Yes.
This judgment was passed by the Honorable Justice Amrita Sinha on 30th March 2023 upon the writ petition filed by the present petitioner. In this writ petition, it has clearly directed by the Lordship in middle portion. Efforts shall be taken to conduct the joint spot inspection upon prior notice to all the parties by 30th April 2023. Final order shall be passed by the Commissioner within a period of 8 weeks from the date of service of a copy of the joint inspection report upon all the parties. The cost and charges for joint inspection by the court-appointed engineer. There was one court-appointed engineer also appointed by the Honorable Justice Vivek Chaudhary in previous litigation. The cost and charges for joint inspection by the court-appointed engineer shall be borne equally by the complainant and the owners and the occupiers of the subject structures. The previous joint inspection report prepared by the inspection team is liable to be ignored. Your Lordship, here the Honorable Justice Amrita Sinha observed about the ignorance, about ignoring the previous report. Against which this order, we as a private respondent preferred the appeal before the Honorable Division Bench, and the appeal was heard. And now I like to take your Lordships in page number . In page number 172, this is the judgment pronounced by the Honorable Justice Arijit Banerjee and Honorable Justice Apurva Sinha. In
Yes.
page number 172, Your Lordships, the Honorable Division Bench observed, hence we delete only that portion of the order of the learned single judge which says that the previous joint inspection report prepared by the inspection team is liable to be ignored. So the Honorable Division Bench ignored that line. That means that report, earlier report, has kept intact. Because Your Lordships.
Next page.
Please. And I am also coming. I am also coming to the next page also. I am also coming. We, however, clarify that although it will be open to the commissioner, now commissioner has a role. Commissioner to consider the previous joint inspection report, how much credibility or weight will be attached to such report will be up to the commissioner. It is the commissioner. Particularly in view of the fact that such report was prepared not in the presence of the respondent writ petitioners. The respondent writ petitioners may record their exception to here. The respondent writ petitioners may record their exceptions to such report before the adjudicating authority commissioner. Our attention has also been drawn to a notice dated April 18, 2023, issued by the Commissioner of SMC, addressed to various officers of SMC. The notice is to the effect that pursuant to the order dated March 30, 2023, a technical team under the Executive Engineer Siliguri Municipal Corporation will conduct a joint spot inspection of the building site at Pani Tanki Mode, Sevak Road, Ward number 10, in reference to the above WPN number. 28/4/23 was the date fixed, and this notice was received by the petitioner. 28/4. You are accordingly directed to remain present at the said site at the time of inspection, along with a copy of the sanctioned building plan and any other relevant valid documents. We are of the view that the inspection team should also include Mr. Puranjay Konar of B20/1, Nandan Kanan, third floor, Santoshpur, Kolkata, who is an engineer empaneled with this code. This order shall be immediately communicated to the Commissioner of SMC. Mr. Vijay Bikram Das, learned advocate appearing for Siliguri, shall also communicate this order immediately to the Commissioner to the Corporation. Page 174. We clarify that all future inspections are to be held by a team of which Sri Konar shall be a member. Since today is April 26, 2023, it may not be possible for Mr. Konar to make himself available at Siliguri by day after tomorrow. Hence, we fix the date of inspection at May 2, 2023 instead of April 28, 2023. As is mentioned in the notice issued by the Commissioner of the Corporation, the order of the Lordship single judge will stand suitably modified to the above extent. Your Lordship, the order was to complete the inspection within 30th April. And accordingly, the Commissioner issued a letter dated 18th April 2023, fixing a date of joint inspection, giving a date 28th April. As this matter was heard by their Lordships on 26th April, and only one day was left in between 28 and 26. So the Honorable Division Bench extend the said period up to 2nd May. And specific date mentioned 2nd May. This writ petitioner was a party in the said appeal. So they were aware about why they did not appear before the inspecting team on 2nd May. Your Lordship, they have challenged after they have challenged this 2nd May inspection on 21/6/P11. P11 is their letter of challenge submitted to SMC Siliguri on 21/6/2023 at page 205. Kindly peruse this letter, Your Lordship. Very vital document submitted by the petitioner, writ petitioner. Page 205. Now,
Where is the order extending the rescheduling the inspection?
there is no order passed by the Honorable Court because the Honorable Court given a deadline. Because Your Lordship, this
The date was on 28th April.
28th April.
That date was extended to 2nd May.
2nd May.
Who has extended this?
So Honorable Division Bench.
Where is that order of extension?
Honorable Division, I have read out just that order in page number 1, page number
173.
Oh, it has been subsequently, yes.
Yes. So subsequently, by order letter 26. Now, complete. So this, they have challenged after 2nd May inspection hoche, unara chithi dichen 21st June. After a period of 1.5 months, why they did not object on the same day? Unara chithi dekhle, it will be clear that they were present before the inspecting team. 2nd May te unara present chilen. Kindly peruse.
Where is the document?
Page 205.
So why was the second notice issued?
Yes, may I clear?
No reason. No reason. Only.
Sir, please, may I clear? Lordship, there was an earlier inspection notice. That inspection notice was set aside by Justice Amrita Singh. Now they went up.
The inspection report was set aside, not the
Inspection report-
notice.
Inspection report. Inspection report was set aside by Justice Amrita Singh. Now they went up in appeal. The appeal, the division bench said that since that inspection report was already a part of the record, the Commissioner Siliguri Municipal Corporation may consider that report. And Mr. Puranja Konar, who was the High Court appointed engineer, he will be the part of any inspection if it is carried out by. Now, date of inspection was fixed on 2nd May 2023 at 2 p.m. Now, notices were served. Some of them came, some of them.
Where is the service of notice?
Lordship-
2nd May.
Lordship, if your Lordship comes to this. They have annexed this notice dated 22nd May, but it is there with the.
Page 189.
No, that is the subsequent.
Yes, page 189.
189, you please see the later part, copy 2. Where are the petitioners' names there?
Petitioner's names are in page 186.
187.
But 186, 187. 187.
From 187.
Petitioner is in page 188, the top 9, serial number 9. Serial number 9. They were aware about the date, Your Lordship. This is not a case only to delay the proceedings.
On 2nd May, an inspection was taken place. Now, since all of them were not present, they were raising voices at the inspection site. So the commissioner felt that a further inspection to be carried out, giving everybody a notice. So another notice.
Where
was-
is the service of second May inspection? Only the names are there. Where is the service?
Your,
Page 179,
Page 179.
9, subject joint
This is
inspection.
the second,
your lordship,
this is the second notice.
your lordship,
Since
they have
second
not
notice.
filed.
The
They have
first-
received. they have-
Please, sir, have
your-
some
your-
patience,
your lord-
please.
your lord.
Let the
It
municipality
starts from-
respond.
It starts from page number 175.
179 is the second notice, fixing 31st May.
Yes,
But you say it was held on 2nd May.
second page was it.
Why did you issue this notice, second notice then?
Second notice was issued because on 2nd May, the inspection was carried on. Some were present, some were not. Some of them.
Where is your service of notice of the 2nd May inspection? The petitioner says they have not received any notice. And
Now
the
in
court
this-
did not record that no further notice is required to be served. The court did not say so.
What did it say?
So there was, you had to
Yes.
serve notice.
I had to serve notice.
So where
since
is the
this
2nd May
building-
notice
Now, what
served?
happened? In this building, there are many owners, occupiers, tenants, many. It's not possible for us to find out how many names we could gather. We had served notices upon them.
You will demolish all their properties?
No. Not that the entire building will be demolished. Only a part has been identified.
So whoever is interested, you have to serve them?
I have to serve them notice.
Where
Now
is the
what?
service? Of the 2nd May inspection? The first notice.
The first. notice-
Second notice is admittedly served.
Second notice is
Admittedly served.
Yes.
First notice was not served because there
Since
is
first
no
notice was-
document.
Since first notice was not served on everybody, so second notice was
Yes.
there to serve on everybody.
Yes, and
Now
second
in
notice
second
was,
notice,
second notice was issued on 22nd May.
22nd.
But your report is on the basis of
The second notice was issued on
page
22nd
179,
May.
page 179.
Yes, 22nd May, stating that the inspection will be conducted on 31st
But
May.
prior to issuance of this notice, you have reported an inspection which is held on 2nd May. How?
Yes, I'm coming to that. The, on 22nd May, we have stated that the inspection will be conducted on 31st May. Accordingly, we had sent a letter to Mr. Puranjay Konar, which High Court had said that he will be a part of all the inspection. Now, Puranjay Konar, he replied that he won't be coming for the second inspection unless there is an order from the Honorable High Court. That letter is with us. I have not got it today, but he has specifically stated that he won't be part of any inspection which High Court has not ordered.
So that
he
is
will-
contempt.
Lordship,
That is contempt. The High Court says in all inspections, he has to be there.
he has to be there, but he has specifically said that I will not be coming for the second inspection unless there is a direction from Honorable High Court. So we had to depend on the first inspection.
First
We-
inspection is 2022.
No.
No, second inspection, it was conducted on second.
Second by 2020.
Second
there is
May,
no-
You say that 2nd May, there was no inspection at all.
No, it
No,
was conducted.
inspection was there.
My lord,
Inspection was there.
My lord,
Your
look at-
lordship, your lordship, it will be clear from.
My lord,
the-
my lord,
183.
can I, page, can I just place one line, page 184.
So in any event, a fresh inspection is necessary.
Yes.
Your lordship, it is
No,
not
what is the
needed
harm,
because,
sir?
because the
What is the
We
petitioner,
have no objection. We have no-
your
What is
lordship,
the harm?
your
Because we
lordship,
had already directed that the fresh inspection be done. Mr. Puranjay Konar, he
Yeah.
declined to come. So we had to stop there and
Your-
then we had to accept
your,
the
lo-
earlier
your
inspection.
lordship, I have a strong objection. I am fighting since 2017.
What is your objection about, sir?
2017, your lordship.
Maybe. What is your objection? If it is necessary, it has to be done.
Objection already 2 reports are there, your lordships. They were asked, the petitioner himself was present before the inspecting team on
There
2nd
is no
May.
document. There is
Huh?
no document.
There is the document, your lordship,
Where is
their
the
application, page 205. Page 205. Their application to SMC,
Page?
205.
That is the exception to.
Please,
the-
please, Mr. I beg your pardon, please don't interrupt. I am submitting before the honorable court. 205. In page 206, your lordship. That the 205, that the joint inspection report dated Atho stated that in pursuance of the order dated Atho passed by the Honorable High Court, the joint inspection has been conducted. It also states that all parties have been given a notice dated Atho by the Siliguri Municipal Corporation intimating about the joint inspection and directing all to remain present at the site on Atho. We the undersigned we the undersigned state that as the order dated 26/4/23 passed by the Honorable High Court states about the joint inspection, we had appointed out civil engineer for the date to be present in the site, but no notices intimating the date and time of inspection was
Yes.
ever sent to us.
No notice.
Your lordship, notice was not required because notice was served by the corporation on 24, fixing a date on 28.
That is.
And that was
recorded
changed
in-
by the Honorable Court and he was the party.
That is recorded in the report. The notice was not served. The corporation cannot show any document that notice was served. And this is not your concern at all, sir. You're the private respondent.
I am the
So
private
the
respondent.
notice is between the corporation and the petitioner. So you are not supposed to know whether notice was served at all.
No, I
So
am.
why are you making your
No, no,
submission?
Your lordship, we stay, they were aware about the
They were not
intimation.
aware.
They were aware, this letter clearly speaks. Para 3, we state that as no notices for joint inspection were served upon us, we did not intimate and confirm our civil engineer to be present in the
Yes.
site. To our utter surprise on 2/5. So the order is clear, your lordship, the order of the Honorable Division Bench. Order of the Honorable Division Bench that the inspection will be conducted on.
Did the
2/5.
division bench say that no further notice is required to be served?
Already notice has been served, only the Honorable Division Bench changed the date. Notice, a previous notice, they have not filed.
After
They-
that,
they-
did the division bench record that no further notice is required to be served? If that is not recorded, you have to serve a notice.
Your lordship, had there been any scope to serve the notice, your lordship, the division bench must have recorded such observation that no notice is
Let me
required.
pass an order. Please go in for a fresh inspection.
Because-
Building so many tenants, so many persons, and it's very difficult for us to.
If they are affected, you have to serve the affected persons.
Your
Even
lordship, your lordship,
Even if there
your
are
lordship.
100 affected persons, you have to serve all the 100.
We have to.
That's
serve
the
it.
law.
Your
You
lordship-
cannot hold an inspection without service of notice.
Your
When-
lordship, your lordship, very strong objection I am submitting, your lordship, because the report was signed, cannot be decided in this petition because the engineer of assembly and the court appointed engineer has signed the report. What is harm? They have not spoken
Report
about-
is not being disputed, sir. It is said that
They
the
have put it
inspection
there,
was not
challenge the
held at all.
They have
on that
challenged the
date.
notice, your lordship.
I
They
think
challenge the notice also.
I'll pass an order to the best of my knowledge and ability. Then you'll have the
Your
division.
lordship,
bench.
I will submit the affidavit in opposition, your lordship.
Not necessary,
Maybe hard-
not at all necessary.
Maybe hard because notice was not required, your lordship. Because
How will you
the
improve your
date-
case in
the
your,
date was given, the date was given in the open court.
how will you
The date
improve
of
your,
inspection-
sir, will you please hear the court before you make your submission?
Your lordship, the petitioner was a party in the appeal. And he was present, and the date of inspection was pronounced by the.
I think I've not been able to make myself clear. Did the court record in that order that no further notice is required to be served on the petitioner? Was there a recording in the order?
Your lordship, only the honorable court changed the date.
Yes, I've seen
And-
that. That
and-
is admitted.
And they received the notice, previous notice, they have not filed. They were
Previous
noticed.
notice is not relevant at all, sir. The 2nd May notice, was it served? No, it
Only
was
for
not.
only for changing the date. Because your lordship, the previous notice was issued on 18th
I
April.
don't know whether I'm speaking, am I making it very complicated?
Your lordship, beg to submit your lordship.
Because I'm saying, repeating the same thing, sir, but you're not able to, I don't know, I'm sorry, I think I'm not able to express.
Should be notice fixing 28th April, and that has been changed only date.
Even in our second notice, we found it.
So when there's a
28
change of
to
date,
serve.
another notice has to be issued. When there's a change of date, notice has to be issued. Was that issued upon the petitioner? A very simple question. That the inspection was to be held on 2nd May, was that served upon on the petitioners? No. And the municipality who has issued the notice says
How
no.
is it present, your lordship? Because in the joint inspection report, he refused to sign. He was present before the inspecting team. Page number,
Let him come back
No,
on
what is
affidavits.
that?
Unnecessarily, I don't know how to spend more time on this. Learned counsel for the private respondent submits that he seeks to use an affidavit in opposition in this matter. Bad luck, sir.
My lord, what can be done, my lord? My lord, only thing,
A paragraph affidavit in opposition be submitted within 2 weeks, within 2 weeks from date. Affidavit in reply, comma, if any comma be submitted within a week thereafter.
My lord,
Paragraph, let the matter be placed before the next available circuit bench.
my only thing, no, there should not be any coercive steps by the corporation.
No, no,
That's it.
hearing has already been conducted.
There is no coercive measure. There is no question of a coercive.
No,
measure.
because the hearing notice has been served.
Hearing date was. fixed,
Hearing has already been
and
conducted,
most of
your
the
lordship.
parties gave petition for adjournment, so no hearing was done.
That is it. That's the reason. But that has. Well, since a hearing notice is already been
Complete
staring
your
at.
affidavits in the meantime,
My lord.
because hearing is not concluded as yet.
No,
So there's no
I
question
think-
of a coercive action,
Yes.
unless the hearing is concluded. Yes,
Yes,
next.
that-
Why you not? Lordship, in item number 22, the service is not complete, Lordship.
You are the petitioner.
Yes, I've been asked. Please, yeah, I've been asked. I will inform that the service upon the GP is not yet complete. Kindly please on Thursday or Friday, any day.
There are several private respondents also.
I shall ensure the service on everybody.
Friday,
Friday.
on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on Friday's 4th August.
Lordship, service incompleted, praying for not this week.
On prayer of the petitioner, the matter is since service upon the respondents is not complete, comma, let the matter stand over till 9th August. 9th August.
Lord, I beg to appear on behalf of the petitioner.
Yes, have you served?
My lord, service complete.
Who is appearing for the respondents?
Lord,
It's only the state?
Lord, NBSTC as the answering respondent. Usually, Mr. Vikramaditya Ghosh is appearing on behalf of the North Bengal State
Fine,
Transport.
Mr. Ghosh, yes, this has been served.
Yes, my lord.
I'm the state. It's only the NBSTC or the state also? The state is also there.
To appear for the state.
You are appearing for the state?
My lord, Mr.
What
Ghosh is
about
here,
the
my lord.
NBSTC?
He's here, my lord.
Yes, Mr. Ghosh, you are appearing. Yes.
My lord, the petitioner was engaged as an artisan with the North Bengal State Transport Corporation. Subsequently, he was made a permanent employee in the year 1955, my lord. My lord, subsequently, the petitioner retired from his post of artisan on 28th February 2022, my lord. My lord, after that, my lord, he is deprived of getting his pension, gratuity, and other retirement benefits, my lord. So, representation has been made on 21st of May 22 at page 29, my lord. Similar issue has already been decided by His Lordship Honorable Justice Shampa Sarkar at page 34, annexure P5, my lord.
Page 22 is your representation.
Yes, my lord. Page 29 is my representation, my lord. 29
Yes.
to the chairman and the managing director, and similar issue has been decided by earlier, my lord, by Justice Sarkar, my lord. Here also the petitioner was working with the State Transport Corporation, my lord, and in the same post as an artisan, my lord, he was deprived of getting his retirement benefits, my lord. Subsequently, Justice Sarkar ordered that after rendering 20 years of service, more than 20 years of service, that retirement benefits has to be paid in favor of the petitioner, my lord. Mr. Ghosh already appeared in the said matter, my lord.
Earlier, Justice Sarkar directed that the managing director should consider his prayer afresh.
Yes.
Keeping in mind that the police verification report after retirement may not be relevant. if he is otherwise entitled to do the.
But in this
May I-
matter, has the police verification report been
As per my
called?
instruction,
No, no,
my,
it has not. been-
That is not the case at all. So in this matter, let the representation be considered within a
Yes.
very short time.
Yes, yes, yes.
my lord, as per my instruction.
The
due to-
order that you're referring to is a
Yes, my lord.
second round.
Yes, my lord.
Yes?
Yes, my lord.
So let this be considered. If you are lucky enough, you need not have to come back to court for a second round, isn't it?
Let them refer to this order before the authority.
Yes, yes, you can do that.
Yes, my lord. My lord kindly records that order, my lord.
So I can at best observe that in the light of the order passed by a
Yes,
coordinate bench,
Let the
right?
appellate authority
That
decide
should
the
help
author
you.
is involved.
Grateful, my lord.
Affidavit of service. The state has anything to add? I don't think so.
No, no.
Joint affidavit. The state has anything to add? No, no. It is contended on behalf of the petitioner that the petitioner was employed as an artisan, ARTISAN, artisan with the North Bengal State Transport Corporation since 1995 and was brought into the regular establishment of the corporation with effect from 1st July 1994. 1995 appointment, regularization.
He was made
1994.
permanent in 11th of October 1995.
He was appointed in 1995.
Appointed in 94, my lord. Page 21.
Paragraph 3, appointed permanent in 1994. How? So he's in service since 1994.
94, he was in service, my lord. Subsequently, he was made permanent in 95, my lord.
You have stated just the reverse in your writ petition.
I
You have stated appointment in 95, permanent in 94.
tender my apologies, my lord.
It is contended on the petition of that. The petition was employed as an artisan, artisan with the North Bengal State Transport Corporation and retired, from service in 2022. No, 2020, all wrong dates in your petition. When did he retire?
Retirement on 28th February 2022, my lord.
Retired on? Where is the document? Superannuation on 20
Lord,
and retired on
Annexure
28
P3, page 25.
28 February 2022. Stop. 28 now. 2022. The petitioner complains that he has not been granted what is the impugned order of 24th December 2021?
Lord, the order is at page 34, that
And you have
Justice
not
Shortkar
mentioned-
order. Justice Shortkar's order.
No, 24th prayer A of your writ petition.
Lord, typographical error.
Withdraw, file a fresh writ petition, sir. So much of error cannot be considered. The prayer itself is wrong. What are you asking for in the writ petition? You should be more careful, sir. That is the only prayer. 24th December order should not be set aside. What is that order? And there is no other prayer.
My lord, I shall file a fresh with the Liberty, my lord. Liberty.
Withdraw, file a fresh writ
Withdraw,
petition.
file a
And
fresh.
please be more careful. Affidavit of service. Here is input of the petitioner seeks to withdraw the writ petition on account of certain defects detected therein and seeks further liberty to file a fresh writ petition on the same cause of action. Mr. Ghosh, I hope you have no objection to this.
No.
Paragraph in view of the above, comma, the writ petition being WPS such and such is dismissed for dismissed as withdrawn. Liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no arrears to costs, urgent certified. etc.
Grateful, my lord.
Next.
My lord. Sure, go ahead. 25, my lord, service is complete, my lord. May I hand over?
Municipality is there.
Municipality is
I have
second.
no role to play in this matter.
You have no role.
Yes, sir.
Yes.
Already order has been passed, now it's up to the state.
Who is appearing for the state?
Order has not been passed.
Yes, order has been passed.
Not upon the state.
Private respondents?
My
Sir?
lord, sir.
Anyone appearing for the private respondents?
No, well, no one is appearing. My lord, there are two private respondents, my lord.
Right.
Both have been served. Well, it's an VRL.
আমাদেরকে ডাইরেকশন আছে কোথায়?
Yes.
My lord, this is, my lord, pursuant to a notice served by the Siliguri Municipal Corporation stating that to demolish the building, my lord. It's an old dilapidated building, more than 100 years old, my lord. That a building to be demolished. There's an elaborate proceedings, my lord. There was an elaborate proceedings which is done. Tenants were given notices, tenants were served way back in 2017. We'll place that, my lord. My lord, here we are on a particular issue, my lord. There's a small 95% of the building has been demolished. There is only two shops room that is there. My lord, they have this two shops rooms there. From 2017 to 2023, that could not have been demolished.
The private respondents.
By the private respondent. My lord might want to hear the private respondent as well before passing the order, but still, my lord, I will just want brief, my lord, because we are compelling police in action. My lord, page 57, my lord, is the crux of the matter which starts at an extra P10. Man. What happens here? 57.
Yes.
My lord, this is an order, this is an letter, a request, my lord, a request written by the Siliguri Municipal Corporation to this Police Commissioner of Siliguri to, my lord, enclosed, please find the copy of the order of 14/9/2018. This is the main order, my lord, at page 43, that will place, my lord, passed by the Commissioner Siliguri.
Page 43?
Page 43. Page 4. My lord, this is the final order. May I read it, my lord? In pursuance of the direction of the Honorable High Court, Calcutta, dated so and so with memo number so and so, dated so and so, hearing was conducted on 13/8/2018 at the chamber of the undersigned. Having heard both the parties on the basis of the structural stability report of the building by Sri Avik Chakraborty, impaneled structure engineers with Siliguri Municipal Corporation, as submitted by Narsingh Agarwal and Kishan Agarwal, proprietor, and also as per the report of the technical officers of the office headed by the assistant engineer and the SMC, the building is apparently unsafe and unfit for human habitation. Now it is hereby ordered as per section 267 of the West Bengal Municipal Corporation Act, read with subsection rules 170 of the West Bengal Building Rules, it is hereby ordered that the owner of the proprietor and the tenants to immediately take corrective measures to either exhaustively repair
the
said structure or to demolish the structure within 30 days. This was the order. My lord, the demolition had started, my lord. Now, in between of the demolition, my lord, one of the tenant goes to the High Court. Now the High Court says, no, you give everyone a hearing. All tenants hearing, then pass an order of demolition. And then hearing was conducted. A demolition order was again passed after a hearing. After looking at the structural report, the demolition order was again one of the tenant went to the High Court. Now that's very important, my lord. This is at page 48. It starts at 44. It's Devanshu Bosak's order, my lord, page 44. 40 starts at page 44 and end my lord, the relevant portion is at page 48. My lord, it's on the third paragraph, my lord. Can I just read it, my lord? Page 48, third paragraph.
Yes.
The impugned order dated September 19, 2018, the one I was reading, the final order of demolition, directs the owner of the tenant to repair the building. The petitioner claims itself to be a tenant is entitled to repair the building in terms of the impugned order. The petitioner claims that the building stands demolished. Since the impugned order stands implemented, there is no scope for further interpretations of the read court. It is open of the petitioner to able see with other.
He is not the private respondent. He is some other tenant.
He's some other. He's some other. He's no more.
You are asking for implementation of the order.
Of the final order. Now,
in respect of those two tenants who has not been.
No. Now in between what happened? Similar, they file an application before the civil court. There is a civil court. Similar orders not to evict without due process of our law has been prayed for. That is also passed. Now the appeal court also says, now in appeal also, my lord, we have appeal court says no, you cannot obstruct that in carrying on because my lord, by the provision of Siliguri Municipal Act, my lord, if an act taken by the corporation for demolition, the act itself bars the remedy from civil court. That is there.
Right.
So, my lord, we have asked for police protection. My lord, a small part of that. The commissioner, Siliguri Municipal Corporation also writes to the police commissioner, look, please implement my order. My lord, it is not written. No. It's not written. No. It's not written. But you have to read the content of it.
Don't submit something which is not there in the document. Please don't.
My lord, if it is take necessary action of my final order, what does it mean?
What is the final order, my lord? If I may. My lord, if I may have your lordship on page number 43, that is the final order passed by the corporation. It doesn't speak of enforcing the order by police assistance. There is no question of police assistance that is involved in this case. It is the landlord and the tenant who have themselves admitted to demolish the building by themselves.
Yes.
But
no police assistance was sought at any point of time.
Why we are not seeking of police assistance also? I'm not. What we are saying
How can
that there
the
is
police
unnecessary. My lord, a building which is hanging. Now, if I go there to demolish the building, my lord, there somebody comes up because there are.
Have you approached the municipality stating that they have not complied with the order?
Yes, my lord. Again,
Where is that?
That's later, my lord.
Because here the municipality directed the owners or the occupants
Owners
to either repair or demolish.
That was also the High Court.
Not to any other authority.
Not to any other.
The authority did not also say that we will demolish.
Yes.
That is also not.
That is also.
My
lord, page 55, we state our problem. What is happening? We go for demo. We are ready to demolish, but then what happens? My lord, it's on the middle of the road.
Nowhere these issues were raised before the
page 55.
These were never raised before the commissioner, not they were raised before the coordinate bench of this honorable High Court in the earlier read petition.
No,
for the first time that the petitioner comes up with this particular point that he is not unable to demolish the same due to interference or something like that.
But we file an application and
their responsibility, my lord, to demolish the building. They have to do it at their own cost. They have to do it at their own on their own. It's either the
you are the owner.
We are the
building.
We are the owner.
He has an ongoing dispute with his tenants. That is the crux of the matter. The tenants are not allowing him to demolish the building.
Has this representation been considered? The application under 268(4) at page 55.
my lord, after this application at page 55, what is done by the commissioner is at page 57. What is done is only at page 57. That this is the only letter that has been written by the commissioner at page 57 to the police commissioner.
This is just the mere communication of the order that was passed by the commission.
This is different from this.
Yes.
When was your representation submitted?
Yes.
My lord, the representative was submitted, my lord, on, my lord, will see 4th May.
Where is the date?
My lord, at absolute on the bottom, my lord, at page 55, there is a
This
seal.
is 4th or 1st?
My lord, it's first. 4th. No, first.
It's illegible actually.
4th of course, yeah. What a commissioner, my lord, what can you, cannot direct the police commissioner. What at best, he said, look, this is a matter, see to it. That's the other thing.
No, the commissioner can ask for assistance if he thinks so, if it deems fit.
Kind information and further necessary action.
Necessary action, necessary
But
action.
the police is not involved at all in this matter.
But
Let your representation be
police is not
considered by
involved.
the
I
authority.
can understand, ma'am. Police
Let-
is not involved.
Let this representation be considered by the authority.
My lord,
Let the authority give a specific direction upon the police
my lord. Grateful.
for implementation.
Great.
Direction, let them seek assistance of the police. That can be done.
We are seeking by way of this writ petition,
After giving opportunity of hearing to all the sides.
all the sides. We are seeking by,
It's the commissioner, Siliguri Municipal Corporation who has to initiate the.
The representation says necessary steps for demolition of the entire building.
Yes.
You have not added police assistance there.
No.
my lord,
With
the last,
with intimation to the IC
my lord,
Siliguri Police
my lord,
Station.
the last line, my lord, police.
Intimation. Do you see the last line?
Yeah, with the intimation in charge of police for necessary police help, necessary police help.
Let this representation be
If I
considered.
may, if I may read out the relevant portion of Rule 268, what Rule 268 says, is the power to order demolition of buildings dangerous, ruinous, or unfit for human habitation. It is the commissioner who has the power to order such demolition.
The commissioner has done.
Commissioner has to order such demolition. Either the commissioner orders the owner of the building, or the commissioner orders the owner along with the tenants of the building to carry out the demolition at their own cost and expenses. And in the instance they need any police help, they have to requisition the police by paying the necessary.
The commissioner has to do that.
But the commissioner has to direct the owner or the occupier of the building. As per Rule 260. I hope.
So that direction was already given
Given.
to the owners and occupiers,
They
either
have
repair
not
or
been able to-
demolish.
They have not been able to.
What is the next step for the commission?
But then they have the owners here, the owners of the tenants, they have to resolve the dispute. They have to come up to the commissioner and say that we have not been able to do it, kindly pass necessary order.
That is
They have not
exactly
done.
what is stated in the
268(4).
representation.
268(4), that is
That
we
is
have done.
exactly what is in
Yes.
the representation.
That is,
So let the commissioner decide the representation
commissioner
upon
decide.
hearing all
Upon hearing
the
all the parties.
affected parties.
yes, yes.
Affidavit of
We are ready to pay
service.
for police help. That's we are there.
Paragraph none appears for the private respondents despite service. Paragraph.
Police like.
Assumes. No, no, simple already has been already passed.
The petitioner has sought implementation of the order dated 14th September 2018 passed by the Commissioner, Siliguri Municipal Corporation directing the owner and the tenants of the building in question to take immediate corrective measures for exhaustive repair of the structure or demolition of the same within 30 days from issuance of the order. Paragraph. Learned counsel for the petitioner submits that pursuant to the said order, comma, though major part of the building has been demolished, comma, the private respondents who are running their shops
Sure.
in a portion of the building have neither repaired the said portion, comma, nor demolished the same in compliance with the order of the Siliguri Municipal Corporation. The petitioner seeks, the petitioner submitted a representation in this regard before the commissioner,
Only, my lord, can I?
requesting necessary steps for demolition of the entire building
Yes.
with intimation to the police authority for rendering necessary assistance for the same.
Kindly make Siliguri Municipal Commission, Siliguri Municipal Corporation after the word commissioner. Otherwise it would mean.
আচ্ছা। যেটা বললাম না, কমিশনার এক্ষুনি representation to the commissioner. The commissioner, comma, Siliguri Municipal Corporation. Commissioner, comma, Siliguri Municipal Corporation. Stop. The representation is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the third respondent, third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated. You say it is 4th May.
Well, that's what it's it, but it looks as one, my lord.
It looks as one.
One, right.
That's
Zero
what
one.
I was feeling. ওখানে যে representation করেছেন, ওখানে on 1st May 2023 করেছে,
My lord, only one indulgence, my lord. I'm just placing, my lord, 268.4. My lord, that's it. That's the trouble. একটু দেবেন এটা? This application is made under, my lord, 268.4. My lord, it says like if the order is not, if the petitioners, if the owners are not able to comply with the order, it is the commissioner who will comply.
Yes.
Kindly have a look at 264.5. The expenses are to be recovered.
Yes.
He's ready. He's willing to. bear the expenses.
But kindly include this.
ওখানে representation এর জায়গাটা বলুন। না, এই last, the petitioner submitted a representation. Commissioner, ওখানে করুন on 1st May 2023 under section 268 within bracket 4 of the West Bengal Municipal Corporation Act, comma 2006, requesting. কি বললাম এবার requesting? The petitioner. The petitioner
I'm sorry,
is ready and willing to bear the expenses incurred by the commissioner for the purpose. I've recorded that you're ready to bear the expenses.
My lord, this 1st May is holiday, my lord. It will be 4th May. Labor Day.
Could not have been received on 1st.
Yes, could not have it. 4th May.
দুটোই 4th May. Paragraph, in view of the above, comma, the petition is disposed of, directing the third respondent within 2 weeks, 3 weeks. Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law.
Grateful, grateful, Lordship.
Disposed of which affluent.
My lord, affidavit in.
Next,
Great.
I would kindly fix this matter on a senior advocate from principal bench will come for the.
8th.
Lordship,
Eight.
Lordship, may I appear for the private respondents number 6 to 8, maybe file an affidavit, Lordship.
What is the matter? Why do you want to file an affidavit?
Lordship, it's-
Illegal,
I'm
illegal construction, encroachment.
No, Lordship, it's with regard to transfer of a certain tea garden. The petitioners are saying that they have entered into an agreement with the erstwhile lead holder. We are saying that the agreement is not meant, the agreement is wrongful. And also as regards like for temporary accommodation to the petitioners to operate the tea garden, we are saying that our representations are also pending before the authority for the purpose of renewal of our lease. So Lordship, may we bring all those facts on record and Lordship may be permitted to file our affidavit.
Do you agree to this?
My lord, I have no
Instruction.
instruction.
Come back.
8.
Come back on 8th. You
Lordship,
still want to?
Actually, I'm traveling from the principal bench, Lordship, so it might.
The petitioner's counsel will also travel from the principal bench.
I am appearing on behalf of the private respondent number 10. I have no. So Lordship, maybe Lordship, if it could be fixed in the next circuit bench, Lordship, we'll come back with affidavits. Because there are disputed facts that need to be brought on record, Lordship.
You are appearing for?
For respondent number 6 to 8, Lordship.
Learned counsel for respondent number 6 to 8 seeks to use an affidavit in opposition in this matter. Paragraph affidavit in opposition be filed within 2 weeks,
3 weeks, Lordship.
within 3 weeks from date. Stop affidavit and reply, comma, if any comma be filed within a week thereafter. Paragraph, let the matter appear before the next available circuit bench. Next.
All the petitions. 27, my lord, I am asking for the petition.
Service affected?
For the petition is the nominated candidate
Just
under my lord.
You are appearing
Yeah,
for?
my lord, I am appearing for this, all the state respondents, excepting
Yes.
the election commission, my lord.
All India Trinamool
Uh,
Congress, my lord.
My lord, these. just a second.
Accepting the?
Excepting the election commission, respondent number 1, 2, my lord. 1 and 2, 3.
Who is appearing for 1, 2, and 3? Where is your service?
Yes. All affected, my lord.
Generally, we do not appear, my lord, election commission, my lord.
There is another set of.
Yes,
counsels
election
for-
commission generally represent through their own respective lawyers, my lord. Because we did not receive any instruction with regards to that.
But
But
is it
the state
served?
respondent, my lord,
Are they served?
Yes, ma'am. Also, all affected, sir.
my lord, may I make a suggestion, my lord?
Yes.
My lord, this what from the your lordship's list appears. This is the item number 27, 30 and 31 lordships with regards to the election related matter, my lord.
Yes.
For either recounting or for repolling, my lord. So, my lord, my suggestion would be, my lord, there are also others matters even. We have received others in similar circumstances with regards to the other constituency, my lord. So let all these matter be decided or be heard, my lord, in a one day, my lord. Either, my lord, Friday or Monday, then that would be a convenient, my lord.
But who is appearing for the?
In
election
the meantime,
commission?
that's why, my lord, in the meantime, today is, my lord, a Monday. In the meantime, also we'll seek instruction whether election commission is being represented by the respective lawyer or we will represent. So in this matter, the others matters also even
This Friday?
All matters.
all pertaining to that. In the meantime, the all election related matter, my lord, is let it appear on
I
either.
cannot make a blanket order. Let this matter be fixed on Friday. As and when the matters come, I'll fix them on Friday. Please
These
mention and I'll fix them. on
Three
Friday.
matters, 27, 30, 31.
You are appearing in all these matters?
My lord, state, my lord.
And you are the petitioner in all these matters?
But-
Only on, in respect of 27.
So I have to call one by one.
Lordship.
I'll just call one.
Oh, lordship.
He is appearing for other two matters.
I'll call. I'll
And
call.
one matter, tomorrow
Affidavit
is
of
appearing
service.
lordship.
I'll call one by one, sir, please wait. Affidavit of service. Since respondent numbers 1, 2, and 3 are not represented, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on, you're asking for Friday? 4th
Election.
August? 4th August?
The election commission, I do not know whether you will serve, make a fresh service or not, that I do not know.
Service is there. Will you serve a notice intimating the adjourned date?
That would be better.
Yes, do that if you can. I'm not giving any direction.
4 to 7, my lord, we are representing. Respondent number 4 to 7.
Well, 1, 2, and 3.
Yes.
Yes, next, 4th August. Next.
তুমি 30, 31 দুটোতেই আছো?
My lord, my lord.
Yes.
My lord has taken up, my lord will kindly pardon me. Item number 23, since the service was not complete, my lord was,
23?
27.
since the service was not complete, my lord was pleased to fix it on next Wednesday, my lord. This is an election matter, my lord. So my lord will be taking up all the election
23.
matters.
That was not submitted,
Yes,
sir.
it was not submitted. I apologize. My junior should have said that.
And the order has been passed. I am sorry. Come back on next day. Let us see what I can do. 28.
Lord, I picked up on the petitioner.
Yes, have you served?
Yes, my lord.
Who is appearing for the National Highways?
I am appearing on behalf of the National Highways Authority.
What about the state?
Served, my lord.
Who is appearing for the state? You are appearing, sir?
No, my lord, in
28.
28, my lord, not I am not presenting, my lord, state advocate, my lord.
Who is appearing?
Lordship, I beg to appear for the state in this.
You are appearing, very well. Yes,
My lord, petitioner is the owner of the land, my lord, recorded owner. My lord, page number 13 is the LR Khatian recorded in the name of petitioner, my lord. My lord, kindly takes up page 21, my lord. My land has been acquired under section 3G subsection 4 of National Highways Authority of India Act, my lord.
page?
Page 21, my lord, is the acquisition notice, my lord, from the National Highways Authority of India. My lord, page 22,
Yes.
my name appears Dinesh Sarkar, my lord. I am the petitioner, my lord. Since then, compensation has not been disbursed in my favor, my lord. Several representations were made. Last representation was made on 15th February 2023, my lord. Till date, the petitioner is deprived of getting compensation, my lord.
Yes, the respondents.
Lordship, I seek some time, Lordship, to get the instruction, Lordship.
What instruction do you need? You have to pay compensation.
Lordship, actually, I don't have any instruction regarding this matter. That's all. Only allow me 2 days accommodation, Lordship.
My lord, kindly takes it up tomorrow.
Can you take instructions?
days,
in a
Lordship.
day?
Because the National Highway Authority already payment has been done on the part of the National Highway Authority.
You
Now
have
the
deposited it before the competent authority.
authority, entire Moja compulsion. This case is relating to the Moja Marich Bari.
My lord,
So in that case, a report is necessary from the state.
My lord, as per my instruction, my lord, respondent number 6 is the answering respondent special land acquisition collector, and till date the payment
Let
is
them
been.
come back with a report. Because
Respondent
the
number 6
National
shall,
Highway says they have deposited the entire amount.
yes, my lord.
So now it's for the competent authority to disburse.
My lord, respondent
Yes.
number 6 is the
So
competent
whether they
authority.
have disbursed, why, if they have not, why, let them come back to the report.
Yes, my lord.
Affidavit of service. The petitioner complains that though his land has been acquired by the respondents, comma, no compensation has been paid to him till date. Paragraph, learned counsel for the National Highways Authority of Highways, Authority of India subjects, paragraph 2, that the entire compensation in respect of the relevant moja, being moja Marichbari, Marichbari, has been deposited before the competent authority. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Please come back with a report in the form of an affidavit. Paragraph, let the matter next Monday. Yes. Paragraph, let the matter appear under the same heading on 7th August. Please serve an advance copy of the report so that we can deal with the matter.
I'm grateful, my lord.
Next.
My lord, I am for the petitioner. My lord, I have served all the respondents through speed post, but as per the consignment report, it is not yet delivered. So I need few more.
Serve and come back.
Yes, ma'am.
So will you come
Yes,
back
ma'am.
next week?
Yes,
Can
my
you
lord.
complete service by
Next
week?
Monday, my lord.
On prayer of since service upon the respondents is not complete, comma, let the matter appear under the same heading on
Next Monday.
7th.
Yes,
7th
yes,
August.
my lord. Grateful.
7th August. Next.
Yes, my lord.
Yes, my lord. 30 and 31, my lord, election matter, my lord. Earlier matter was fixed on 4th.
Fixed on 4th. By consent.
My lord, accepting the election commission. my lord. I am representing the accepting the election.
Since the election commission is not represented, comma, let the matter appear under the same heading on 4th August.
Lordship.
30 and 31.
Yes, Lordship.
Same order. 31, same order.
But I am for the petition, I'm read by Mr. Indranath Mitro, he's in the virtual mode, my lord.
Well, in 32, I am appearing for the petitioner.
Yes, yes.
32.
Service complete.
Yes, my lord. Copy has been served.
Who is appearing for the respondents? You're appearing?
32.
Yes,
I am
yes.
for the petitioner.
Marriage officer. My lord,
Am I audible?
can I come back, my lord, Wednesday?
Yes, yes, audible.
Why?
My lord, because I haven't, because my London friend is saying that it has been entrusted to me. Let's see that, my lord, let me come back day after tomorrow, my lord.
But kindly hear me first, my lord. The issue has already been settled by the Honorable High Court. But kindly hear me only 2 minutes. Hear me only 2 minutes.
Learned counsel has no instructions today. He wants to come
No,
back day
my
after
lord,
tomorrow.
my prayer of compassionate appointment has already been rejected. What instruction he will take? Page, kindly have a look, page 29. Without going through the brief, a mechanical prayer, instruction.
He has actually not gone through the brief. That's why he's asking for time.
I'm not any
That's why.
mechanical
Yes,
prayer.
yes,
I have
my
not
lord.
made.
I bow down, my lord. I bow down.
I have not
Kindly have
made.
a look.
Please come
Page
back day after tomorrow. You want to come back day after tomorrow?
Day after tomorrow, Wednesday.
On prayer of affidavit of service. Paragraph. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 3rd. Day after tomorrow? No, 2nd August.
Grateful, ma'am.
But 2nd August.
2nd August. Next.
I appear for the writ petitioner, my lord. I filed the affidavit of service. I also.
Yes. Who is appearing for the respondents?
State respondent, my lord, served,
Only state?
only state, my lord.
Yes, Mr. Shah, who is appearing?
33.
Who is appearing? You're
My
appearing?
learned friend is here.
Yes.
My lord, one, if your lordship sees the prayer B is a very unusual prayer, my lord, I have.
I was wondering,
Yes,
I
my
am
lord.
on prayer B.
Yes. The situation has compelled me, my lord. My 15-year-old daughter was raped. On 7th of May 2023, my lord, I lodged an FIR before the Moinaguri police station. The FIR is at page 12. On my complaint, my lord, FIR lodged under section 4 of the POCSO and 376(3) of the Indian Penal Code.
Yes.
From the time, my lord, the FIR was lodged, the accused, my lord, started threatening me and my family. Finding no option, I make a written representation before the Superintendent of Police, Jalpaiguri, which is at page 15. From May till today, my lord, the constant threat is going on.
And this has not been considered?
No, my lord. And yesterday, my lord, I got a instruction that an application for anticipatory bail, my lord, has been prepared before this honorable court by the accused. Since it is a POCSO case, my lord, notice has been served upon me. From May.
That you will have an opportunity to oppose.
That
That's
I
a
have,
different
but I
issue
am bringing it to
altogether.
your lordship's kind notice, my lord. But since May till date, nothing has happened, and I am under
Yes.
constant threat.
No,
Me and my daughter.
We have registered a case under this. You registered a case, one of the accused is absconding.
Accused is absconding, but he has filed an anticipatory bail application.
You have also a date in the house. You have a report from the.
These are issues which need to be addressed
I understand.
strongly, isn't it?
But this is addressed to the additional government period. This report.
Investigation is going on.
No, I have no quarrel with that, my lord. But my and my daughter's safety, my lord, that is the biggest difficulty. FIR was duly registered under the relevant provision, my lord. I have no grievance with that as well.
Approach the bail court, bail court.
That
With your allegation of
Yes.
the safety part.
Yes. But
Because
will
the
it-
writ court cannot give a.
no,
directive
I
for
know.
arrest.
Prayer B, my lord, I know I cannot get.
I can direct consideration of your
Yes.
representation, but that has already been dealt with.
That has been already.
Pursuant to your representation, this has been done.
Okay, may I get a copy of the?
I'll hand over a copy.
Very well, my lord. As your lordship.
This will help you in your
Yes,
appeal.
but-
So will you withdraw the writ petition? Will
Uh,
you withdraw? Because I cannot pass an order in
I
this.
know. Okay, will it, my lord, can you take it?
Let me dispose it of recording that your representation has already been considered.
As your lordship, please.
Right?
As your
Yes,
lordship.
it's.
Affidavit of service. The grievance of the petitioner is that her minor daughter, aged about 15 years, was raped was sexually assaulted. Was sexually assaulted by one Pratap Sarkar. For which the petitioner lodged a complaint before the police on 7th May 2023. Stop. Since then, the accused person has been threatening the petitioner and his family with dire consequences. Stop. The petitioner submitted a further complaint before the police authority in this regard on 15th May 2023.
Before the SP Jalpaiguri, Superintendent of Police. At page 15, my lord.
Before the police, before the superintendent of police Jalpaiguri. Before the superintendent of, before the police authority, before the superintendent of police, Jalpaiguri, on 15th May 2023. But no steps have been taken by the authority pursuant to the same. Stop. The petitioner seeks necessary direction upon the authority to take necessary steps in terms of the complaint lodged by the petitioner. Paragraph. Placing reliance on a report submitted by the Inspector in Charge, Moinaguri Police Station, Jalpaiguri, Learned Counsel for the respondents submits that pursuant to the complaint of the petitioner, a specific case being Moinaguri Police Station case number 166/2023 under section 4 of the POCSO Act, read with section 376 within bracket 3 of the Indian Penal Code, was registered and the matter is under investigation. Stop. Paragraph. In view of the same, this court is inclined to hold that since steps have been taken by the police authority pursuant to complaints lodged by the petitioner, nothing further remains to be adjudicated in the present writ petition. Paragraph. The writ petition being such and such is accordingly disposed of.
Yes.
Okay, exactly. No rest to cause since.
Read
affidavits
from that
are
also
just-
fine.
Will
Yes.
it be Lordship's pleasure to mention that in the report, as I have just gathered, that raids have been conducted and he is absconding, my lord.
Yes.
It is mentioned in the report.
Yes, my lord. So there is nothing to which it is on the report, my lord.
The report is on record.
Yeah, there is on record, my lord.
And you are going to place the report, I'm sure. Before the.
I will be placing your Lordship's order before the
very good.
Honorable Division
Rashid.
Bench.
Rashid. The report যেখানে বললাম না, investigation কি বলে, is pursuant to the complaints. 4 of the POCSO Act has been initiated. এখানে several বিষয় তাকে লাইন অ্যাড করি। So what is the report?
On the report. I'm sending another copy. It will report to them. Yes, report to them.
একটা লাইন অ্যাড করবো ওটা করবো। Several raids have been conducted. in the house as well as the surroundings of the accused, but the accused was found absconding.
Grateful, my lord.
Okay. তারপরে যাবো।
If I can have the report back.
Yes, yes.
এটা
ওইটা ফেরত দিবেন, আচ্ছা। Next.
Madam, I am on behalf of the petition. Madam, service has been duly made, Your Lordship.
State who is appearing?
Lordship, I beg to appear for the state lordship.
Very good.
Read by Mr. Hero Kwano.
You are for the private respondent?
I am for the private.
Right. Yes, what is the matter about?
Lordship, the respondent number 7 has blocked the egress and ingress of the petitioner by raising the boundary wall and also enclosed the land of the PWD. And also raised an unauthorized construction and structure regarding my and blocking my entry and exit regarding
Where
my
is the
path.
structure raised? On your land?
Lordship, the
On PWD land?
in PWD land, and it is hampering my entry and exit, Your Lordship. Lordship,
Where is your representation?
Lordship, earlier the same type of
Not necessary. Where is your representation?
Lordship, I have made a representation on annexure P6, page number 73, Lordship. Lordship, a same type of relief was been asked by the earlier by the respondent number 7, Your Lordship. Whereby
Respondent number 7.
7, Lordship, whereby the learned court, Lordship, passed an order of regarding passed an order dated to 1/3 of 2023.
Have you annexed the order?
Yes, Lordship. It is at page number 70 P5, Lordship.
70.
And in that said order regarding the joint inspection upon the prior notice to the petitioner as well as to the private respondent to ascertain as whether any construction has been made over the PWD by any
You were
private
the private
party.
respondent in this matter?
Yes, Your Lord.
In the
Earlier matter.
There I
Lordship.
was the petitioner.
And he was the private
Private
respondent.
Thereafter, Lordship, if you see kindly page number 77, Your Lordship. A
Give me a
notice
minute,
was
give me a
been
minute,
sent,
please.
Lordship.
So this joint inspection was held in terms of the earlier order?
Yes, my lord.
Lordship, regarding this said notice, Lordship, where it appears that it has been said that I was been illegal constructed upon the particular land, Lordship. Whereas, Lordship, after that, the representation which I have made, Lordship, at annexure P6, where I have stated that upon the same land, Lordship, the respondent number 7 has also constructed the same, Your Lordship. And as per as the order, Lordship, if found, Lordship, then it has to be demolished. And not only that, Lordship, that construction is hampering my entry and exit, Your Lordship.
So actually, both of you are sitting on government land,
PWD.
the petitioner as well as the private respondent.
My allegation was that the petitioner now before your lordship, my lord, has raised a wall hampering my ingress egress, and that wall is on the PWD.
Now that part is over.
That part is over.
A section 10 notice has also been issued.
Yes, while joint inquiry was held,
Joint inquiry was held pursuant to the earlier
earlier
petition.
order.
But let there be a fresh inquiry with respect
Yes,
to this
Lordship.
petition.
One inquiry, Lordship.
And my lord,
Lordship,
just as in the last order, the honorable court was pleased to direct that to look into illegal construction by the parties. My lord will also kindly direct, because the petitioner's shop is also there on PWD land.
Lordship, if your lordship kindly see the annexure P, annexure P6, lordship, I have already stated there in lordship.
And their specific
My lord.
allegation is that my alleged construction is somehow hampering their ingress egress, my lord. These points were never taken up during the joint inspection, my lord. Because if your lordship kindly considers the earlier order of the honorable court, the honorable court was pleased to direct the inspection to ascertain any kind of unauthorized construction by the parties. So while my
Yes.
lord, the joint inspection was done, this point was never raised by the petitioner before your lordship now.
Lordship, as far as the earlier order, lordship, it has been
The
earlier.
report of the joint inspection is there before your lordship.
Your lordship, as per the earlier order, lordship, it has been stated that the details of the land where the construction had been made is also missing, lordship. It has not been stated in the earlier petition, lot. It has been not been made clear, lordship, the construction has been made or not, lordship. Therefore, the joint construction has been for the order of the joint construction
The
has been
joint
given.
inquiry, my lord, ascertained everything.
Thereafter,
These
lordship,
points were never
lord,
raised.
And upon such joint inquiry, a section 10 notice was issued upon the petitioner, isn't it?
Upon the petitioner,
Yes.
lordship to demolish the structure, my lord.
Have you filed a representation before the authority?
yes, lordship, the representation has been, I have already been stated, lordship, annexure P6, lordship, kindly consider the annexure P6.
Page,
Page 73, lordship, where I have already been stated, lordship. On quote unquote, the order was been also been stated, lordship.
so let this representation be considered.
Yes, lord.
The private respondent will be given an opportunity of hearing, right?
My lord, subject to correction by your lordship, my lord. Here, they have not said anything about my alleged unauthorized structure, my lord.
No.
No. but
The
in
earlier order was
Lordship.
quoted.
Yes,
Lordship,
but in the representation, my lord, there has been, there is no whisper about any alleged unauthorized construction.
Who has also raised same kind of unauthorized, the last paragraph of page 75.
yes, lordship.
Sir, both of you are unauthorized. So if one is removed, the other also has to be removed.
I am alleged, they are admitted, my lord.
Lordship,
Both are eligible.
order has been passed upon.
So let the representation be considered. This court will not go into merits.
And my lord, if your lordship directs a joint inquiry, again, my lord, joint inspection, then the joint inspection may,
When I pass an order for disposal of the representation, that has to be held.
Right.
Isn't it?
Grateful, lordship.
There is no other option for the authority.
Right.
Affidavit of service. The petitioner complains that the private respondent has raised unauthorized construction on PWD land adjoining his property, comma, thereby obstructing his egress and ingress. Stop. In an earlier writ petition, being WPA 426 of 2023, comma, the private respondent herein alleged that the petitioner raised unauthorized construction on PWD as construction by encroaching upon PWD land adjoining the the property of the private respondent hearing. Stop. By an order passed on 1st March 2023, comma, a coordinate bench of this court disposed of the writ petition directing the block land and land reforms officer, comma, Jalpaiguri Gram Panchayat and the executive engineer, comma, PWD, comma, North Bengal Construction Division, within bracket PWD, bracket closed, to conduct a joint inspection upon prior notice to the parties to ascertain whether any construction was made over the PWD land by any private party. Stop. Pursuant to the order of the court, comma, a joint inspection was held by the authority, following which, comma, notice under section 10 within bracket 1 of the West Bengal Highways Act 1964 was issued upon the present petitioner alleging petitioner for removal of the unauthorized construction made by her on PWD land. Paragraph. Learned counsel for the petitioner submits that unauthorized construction has also been raised by the private respondent on PWD land adjoining his property, comma, thereby obstructing his adjoining her property. Adjoining her property, comma, thereby obstructing her egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on 8th July 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that where is the assistant engineer included? The sixth respondent should be the authority.
Yes,
The
sir.
sixth respondent be directed
So
to
respondent
consider the
of six.
representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of directing the sixth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order,
Lordship.
upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Paragraph, in the event encroachment upon PWD land or any portion thereof is found upon demarcation, comma, the concerned authority shall initiate proceeding under section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion in a conclusion within the time frame mentioned above, comma, in accordance with law.
Good.
Disposed of which document? Next.
I will also complain for bonded accommodation on the ground.
Next week. Come back next week.
Here tomorrow, your lordship.
No, no.
Day after tomorrow, your lordship. Your lordship was pleased to pick one matter on, fourth, your lordship.
Thursday?
Thursday.
Thursday is 3rd.
Lordship.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 3rd August.
Great, your lordship.
Lordship, in this matter, I am for the petitioner, Lordship. Similar other cases are pending. You kindly take it up on Monday.
They are all pending on Monday.
Lordship.
Other matters?
No, Lordship, other matters are pending. I am praying this matter to be taken up on Monday.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on Monday, 7th August. Yes, anyone appearing?
madam.
57?
I'm for
You're
the petition.
Petitioner?
Yes, madam. My lord, in this matter, the private respondent,
Have you served?
yes, my lord.
We have for the Miller, the state response.
Private respondent is served?
Yes, my lord.
Yes.
My lord, in this matter, since the year of 2021, the private respondent number 6, he is the adjacent owner of the petitioner. He started the construction, illegal construction in and over the one-storied building, which is a 30 years old. At that time, this petitioner raised the vehicle objection against that construction. The private respondent tried to convince the petitioner that he got some revised building plan in respect of that construction and he is doing well. And after elapsing of few days, this petitioner could realize that he has no building plan and several representation has been made to the corporation and the other authorities for taking the proper steps, and that representation of that petitioner has not been considered. And ultimately, this petitioner came before this honorable court and filed one writ application, and same was disposed of on 13/4/2022, Annexer P7, page number 39.
Yes.
My lord, consider the page number 2 of that order, second paragraph. While learned counsel appearing for the municipal corporation submits that the building plan was approved on 6th February 1995. And the
Give me a minute. The construction was on your land, on your building?
No. This is the adjacent land. Just adjacent.
Here it is said on the roof of a property belonging to the petitioner. Page 39 says the order, earlier order.
Earlier order 39.
The second paragraph. Relates to a construction undertaken by the private respondents on the roof of a property of the petitioner.
It's a mistake, my lord. It's a mistake. It is not on the roof of the no, undertaken by the private respondent on the roof of the property belonging to petitioner. Yes, it is the mistake, the private respondent. Come to the page number, second page.
Yes.
While learned counsel appearing for municipal corporation submits that the building plan was approved on 6th February 1995 and the premises for rooftop construction was approved and sanctioned on 13th December 2021 and 22nd March 2022 respectively. The date of approval incident on behalf of the police is different. Then we are getting 4 number of building plan, one 1995, another 13th December 2021, and 22nd March 2022, and another building plan from the report of the Polish authority. Thereafter, the direction has been given to the corporation for taking the necessary steps. No action has been taken. Again, the representation has been made by the petitioner to the corporation and the Polish authority also.
You served a contempt notice also.
Yes, I served. Thereafter, please see the page number 43.
Yes.
With reference to the hearing held today, that 23rd November 2022 in the chamber of the undersigned, this is to inform you that a technical team from Siliguri Municipal Corporation will inspect your building in relation to WA such and such number. That was case filed by the petitioner, and the document from this document, we are getting that the inspection will be held in respect of my property. Thereafter, this petitioner again filed this writ application with the prayer as annexed hearing. Thereafter, this municipal corporation sent a order sheet, the copy of the order sheet. After filing this writ application.
Yes.
What are the three parts in that? So the
Then what is the order as found upon the order sheet dated 26/11/2022 by Siliguri Municipal Corporation? As per the submitted report of the joint site inspection by the technical officials of this office, and also considering the representations made by the petitioner, the respondent number 6 Krishna Rakshit is hereby directed to rectify the roof truss work as per the sanction plan within 15 days from the receipt of this notice. Then the allegation of this petitioner has been admitted by the corporation. My question is that, number one, from the, again, I am referring the previous order sheet.
Petitioner has been asked to rectify. The private respondent has been asked to rectify.
Rectify, that has been ordered. But
Yes.
my question is that, my lord, that one building plan which has been approved on 6 February 1995. Another building plan that was sanctioned as per the submission of the corporation, that was sanctioned on 13 December 2021. Another building plan 22nd March 2022. Another building plan which is reflecting from the report of the police authority. Now another building plan is coming as per the, just I filed the document. Please see. In reference to the above WPA number 745/2022, a joint inspection of the building site located Surya Sen Colony, ward number such and such, district Jalpaiguri, was carried on 26/11/2022 by serving a notice being memo number such and such, dated 23/11/2022. Roof truss partial is deviation of the sanctioned building plan, dated 9/8/2021. Another building plan is here. So my question to me, how many building plans this gentleman is carrying in respect of the particular property for making the building? If it is a sanction in the year of 1995, without removal of the old structure, there is no provision to give the building plan to any person.
What is your locus, sir? This is not a public interest litigation.
may, Lordship, may.
How are you affected?
He is residing just beside me, and he is making this construction illegally up to 3 to 4 story building. See the photographs, recent photographs.
In one line of it, this petition is infected. Because after the filing of the petition, this order
Has been passed.
If he is aggrieved by this order, he has to challenge this order and the.
No, I am not aggrieved. Order was rightly passed, but the corporation did not carry. And due to the indulgence of
So
the,
you say that this order is rightly passed?
yes,
The order passed?
order, no, this order, order passed by the corporation, that was not right.
So if you.
That is the safeguard, that has been given the safeguard to the private respondent.
So the corporation is supporting the private respondent?
Yes, my lord.
Right?
Yes, my lord.
So if you're challenging this order, it's a separate cause of action? Because this is during pendency of the writ petition?
During
So
pending.
it's a separate cause of action altogether.
Yes, my lord. This is the separate cause
You
of action.
challenge this order in a separate writ petition in that case, isn't it?
Yes, my lord.
So this writ petition, nothing remains.
Then liberty may be given to the petitioner to file the fresh.
Liberty is not necessary because it's a fresh cause of action.
Yes, ma'am.
You have the liberty under the law. Affidavit of service. Paragraph 1. None appears for the private respondent despite service. Paragraph. The petitioner complains that the private respondent has raised unauthorized construction in deviation of the sanction plan issued in his favor by the Siliguri Municipal Corporation. In an earlier writ petition filed by the petitioner in this regard, being WPA 745 of 2023, a coordinate bench of this court, comma, by an order passed on 13th April 2022, comma, directed the municipal corporation to respond to the representations made by the petitioner within a stipulated time frame. Stop. The paragraph, learned counsel for the petitioner submits that despite such order of the court and service of contempt notice upon the municipal corporation, comma, the order was not complied with. That is your submission.
Yes.
Paragraph. During pendency of the writ petition, the Commissioner, comma, Siliguri Municipal Corporation, comma, in compliance with the order of the coordinate bench of this court, comma, dealt with the representations submitted by the petitioner and by an order passed on 26th November. How can this be during pendency of the writ petition? The order was passed on 26th November 2022.
11/2022.
26th November 2022. The order.
Yes, and see this, it is typed on 1/3/2023.
Hearing was conducted on 26th November and order.
No, order was passed on
Order
26.
was passed.
Here is also the discrepancies as made by the corporation.
Hearing was done on 26th and order was
Communicated on first.
Yes, under this memo number
Ki
dated
bola, man,
1st March 2022.
2022, communicated on 1st March 2023, comma, directing the private respondent to থেকে inverted comma মধ্যে রাখুন তো, to rectify এখান থেকে inverted comma, to rectify the roof truss TRUSS, the roof truss TRUSS, আলাদা নয় সব থেকে, TRUSS, truss work, small letter, work as per the sanction plan within 15 days from receipt of the order. Paragraph. In view of the above, comma, this court is inclined to hold that since the representations submitted by the petitioner before the authority has been dealt with, representations have been dealt with, comma, nothing further remains to be adjudicated in the present writ petition. Paragraph. Accordingly, the writ petition being WP such and such is disposed of. There shall however be no order as to costs. Urgency at certified website.
Deeply.
ওর আগে একটা line করুন। এখানে, ওই nothing further remains to be adjudicated, ওখানে একটা line করুন। The petitioner seeks to assail the order in accordance with law. তারপরে in view of the above. Next.
Deeply.
I am for the respondent authority, kindly not today.
I am for the petitioner.
Kindly
So many
say
not
today,
today's cannot be made, come back next week.
Next week. also.
No, it's a very short matter. I am covered by the earlier order of this court in similar circumstances.
But I have just have not bring up the briefer.
Not today.
Not today.
It will take 2 minutes.
Not today.
Deeply abreast.
Thank you. I have the order. None appears for the parties. You know, none appears for the parties.
We are on behalf of this,
Yes.
on
For
behalf
the
of
state, none appears for the petitioner for the parties. None appears for the petitioner. Stop. No accommodation is sought.
I am petitioner.
Sir. Yes,
Lordship, this case, your lordship, for the revised PPO, your lordship. I am the retired from the, as a assistant teacher, your lordship. I am covered up by the other cardinal bench judgment, your lordships, in the same memo and same disputes, your lordship. In this case, your lordship, lordships, in this case, I am joined in the in 1981, your lordships. Now, subsequently, your lordships, when I am retired, your lordships, the respondent authority give me all the retrial benefit, calculating my service, your lordships, in 1988, your lordships. Now, in 2019, one of the teacher, your lordships, file a writ petition. That is WPA 342/2019. And after hearing, your lordship, the writ petition is allowed. Honorable Division Bench, your lordships, confirm the order of the Honorable Single Bench. Lordship, this is page 63, your lordships, in my writ petition. The order, your lordships.
page 63.
Page 63, your lordships. It start from page 59 and last portion, your lordship, page 63. Accordingly, WPA 342/2019 is allowed, thereby directing the respondent number 5 to immediately issue necessary direction for disbursement of all benefits in favor of the petitioner, taking the scale to be effective from the date of her joining service, that is from August 3, 1981. With only exception of the arrear of salary prior to April 1, 2003. Now, lordship, in this case, your lordship, in 1981, teaching and one single memo, 12 teaching staff and 8 non-teaching staffs were appointed. Now, in 1988, respondent authority issue a memo and says only confirm the service of only 4 teachers. Now, subsequently, your lordship, several petitions, one writ petition is came up before the Honorable High Court, your lordships. Then subsequently, your lordship, in 2003, this is memo number, your lordship, page 37. Page 37, my writ petition, your lordships. Now, page 37, last portion, your lordship, as the matter was long pending to us, it was considered carefully and after taking into account all the relevant factors, it seemed that the prayer is justified and rational, and as such, it has been decided that the service of the above noted teaching and non-teaching staff would be counted from their date of joining. An appropriate scale benefit would also be allowed notionally from that date, that is from the date of joining, and monetary effect will be given retrospectively on 1st April 2003. Now, your lordship, in subsequently one another teacher, your lordships, file and writ petition. That is annexed is page number, your lordship, page 77, that is the opposite portion, your lordships. No, lordship, 71, your lordship, 71. That is Sami Chakraborty versus State of West Bengal, your lordship. It start from WPA 1772 of 2020-21, your lordship.
Yes.
Operative portion, your lordships, page 71. In view of the above, the instant writ petition is disposed of by directing the respondent number 2, 5, and 6 being the director, district inspector of school PE Jalpaiguri, the commissioner, director of school education West Bengal, and the deputy director, director of pension, provident fund, and group insurance, respectively, to take necessary steps to prepare the pension documents to the petitioner and disburse the terminal benefits of the petitioner on and from her initial date of joining, that is 3rd August 1981. Now, your lordships, one SUVRA Bhattacharya, that is the case of revised PPO. I am annexed, your lordships, in page
start from page 73 and operative portion is 77. Now, in this case, your lordship, honorable court, your lordship, set aside the portion that is page 37. 37's memo, your lordship, said portion is set aside. Now, may I permit to read your lordship? Page 76, your lordships. I will start from page 76. Mr. Singhania Lanet, advocate appearing for the petitioner, draws attention to the court to the order passed in coordinate bench on August 29, 2019 in WPA 342 of 2019, SUVRA Som versus State of West Bengal and others, and submits that the coordinate bench on a writ petition deciding an identical issue held that the monetary benefit is also to be paid with effect from their date of joining. Mr. Das, Lanet advocate, appears for the state and does not dispute the legal position that the petitioner is entitled to all the benefits with effect from his date of joining. Heard the Lanet advocates for the parties and consider the material placed, the court had the occasion to decide a writ petition of being 749 of 2022, Ila Chaudhuri Shah, allies Ila Chaudhuri Shah, the state of West Bengal and others on July 11, 2022. After taking note, the coordinate bench decision in WPA 342 of 2019, this court directed the concerned authority to issue necessary direction for disbursing all the benefits in favor of the petitioner by treating the petitioner to the entitled to all the benefits with effect from her date of joining. The said decision in the case of Ila Chaudhuri Shah, allies Ila Chaudhuri Shah Sutra is squarely applicable to the facts of this case. The Lanet advocate appearing for the state in his usual fairness does not dispute the applicability of the said decision of the facts of the case. In view thereof, the portion of the order dated 2nd June 2005 issued by the chairman District Primary School Council Jalpaiguri that the monetary effect will be given retrospectively with 1/4/2003 set aside and quashed. The concerned District Inspector of School Primary Education Jalpaiguri being respondent number 2 herein, the Commissioner Director of School Education being the respondent number 5, and the Deputy Director Office of the Director Pension Provident Fund and Group Insurance being respondent number 6, herein are directed to take all necessary steps for issuance a revised pension payment order in terms of this order and to release all benefits in term of his order of the petitioner. The entire exercise shall be completed with it. I am the same footing, same case, your lordships, and even if appointment letter, issuing the memo letter and the disputed memo, your lordship, is the same. The question is same, your lordships, and so my humble prayer, your lordships, the petitioner is entitled to get, your lordship, all the retrial benefits and your lordship from her date of joining, your lordship. I am annexed the salary slip, your lordships, appointment letter. Lordships, in this annexed in documents, your lordship, lordship, appointment letter P1, page 31, your lordship. Letter of confirmation of service, that is annex P2, page 32, your lordship. Service book, your lordship, P6 and P7, page 40, 41 and 54, your lordship. Last pay slip,
Page 32.
page 32. Page 32, your lordship, letter of confirmation of service,
Yes.
memo number, page 32. Page 32, your lordship, confirmation, probation period, and then confirmation letter, your lordships.
Yes, yes.
And page 3, that is the memo, your lordships.
Page,
Page 3, election P3, your lordship, page 33. Order of transfer, your lordship, in this case, your lordships, I am first I am appointed as a Sishu Mahal school. Subsequently, I am transferred to Umagati Vidyalaya, your lordship. This is the transfer order, your lordships. Page P4, page 36 and 37. That is memo number 633, your lordship, which is last portion is set aside by the honorable court in Subal Bhattacharya case, your lordships. P5, your lordships, is memo number 11 of law 1991. That is your lordship. When you one assistant teacher challenged the memo number of 1988 memo, your lordships, then Honorable High Court's order, your lordship. That is first writ petition. Service book, your lordship, page 6 and P6 and P7, your lordship, page 40 and second of 40 to 54, your lordship.
Will you continue the next day?
Lordship.
Will you continue some other day?
Lordship, my submission, your lordship, I am covered up by the other judgment and the same footings, your
But
lordship.
still have to deal with the amendments also.
Lordship.
Yes,
যেভাবে খুশি তোমার, আমার কোনো
you
অসুবিধা
agree
নেই।
to this?
Lordship,
There is judgment of-
lordship is total.
Yes,
Yes, there are judgment on the same, they are also on the same footing.
come back tomorrow.
Lordship. Lordship.
Third learned counsel for the petitioner. And let the matter, paragraph, let the matter appear under the same heading tomorrow, that is. Of the date being, for further consideration.
Lord.
Item number 40, I'm not facing them. I'm for the petition.
You are not pressing. 40 order. Learned counsel for the
Number 40.
petitioner submits that the petitioner does not intend to proceed with the matter any further. Paragraph in view of the above, the writ petition being WPA submissive is dismissed for non-prosecution. There shall have been no rest to cause para. Not called, sir. Madam, it's not called. This was a withdrawal.
It also withdrawn.
You don't want to continue? Item number 42. Anyone for the other side? Same order for 42.
আমার মধ্যে একটাই ভুল ভুলটাও দেখে তত কম করে আমি তোমার আধার কার্ডে He is the person contributing. I want
লাইভ কাটো ছেড়ে দেবে কাটো